Huh?
Item number 33.
30.
33. 33. Under filing at the respondent, filing affidavit in opposition, it is not tagged with allow me for requisition affidavit in opposition.
You have informed the other side?
Yes, I already served the group.
What do you want?
That record is not from that.
May I please, Your Lordship? May I please, Your Lordship? Lordship, I to mention item number 14, Lordship. Record kindly adjourn for 2 weeks, Lordship. My senior is out of state.
What?
1-4.
1-4.
1-4. 14.
Why?
My senior is out of station.
You do it. It's an LA appeal. What is there? Next.
I beg to mention item number 27, Your Lordship. Matter may kindly be adjourned for 3 days.
This court has disposed of.
Not to the another court, Lordship. Thank you, Your Lordship.
Huh?
Was disposed of by another court, Your Lordship.
Which
Yes.
court?
The court is superannuated. The particular judge is superannuated
Okay, at the request of Mr.
and government.
and Gautam, the matter stands adjourned to be listed after 4 weeks.
My Lord, I beg to mention item number 46 of the supplementary list.
Hmm.
My Lord, this engaged senior counsel, Sishir Datta sir, has some difficulty today. My Lord, may be adjourned for the day.
Okay. We have to extend the interim order till today. Okay, we'll have it after 6 weeks.
My Lord, any shorter date.
What?
My Lord, as per your Lordship direction, we have also filed our affidavit just for today.
Then what is there? We can close it.
It has not brought on record, but
Bring it. Simple thing. Once that affidavit has already come on record, by which you are going to withdraw everything, then nothing remains. You can proceed with the before the recovery proceeding, isn't it? So that is what you want.
my Lord,
Then?
I'll have to seek direction from the senior.
Huh?
I'll have to seek direction from the senior.
Oh. The senior is a senior advocate or what?
It's my
Senior advocate. He is going to instruct you.
senior,
Who is your senior?
V. Sharma, my Lord,
Where is he?
out of state.
He is also out of station. And Mr. H does? All are out of state. Fantastic. Okay. We'll have it as per your convenience after the Bihu holiday.
My Lord,
At the request of the learned counsel appearing on behalf of the respondent number 2 and 3, the matter stands adjourned to be listed again on 24th of April 2024.
okay.
Interim order passed earlier stands extended till the next.
I beg to mention item number 6. The senior counsel couldn't reach. So with the consent of the opposite party, back to it
Item number
at 6.
6. Senior counsel,
Yes, sir. Yes, sir.
what happened?
He couldn't reach. He was out to his native place.
What is the matter about? Look into the matter, then tell me. Yes, what are you challenging?
But here we are challenging an order wherein petition under Order 9, Rule 13 was dismissed. So, Lordship, what has happened in this case that we are the petitioner hearing.
Where is that order?
But there is page 45. So, Lordship, from the order itself, some basic facts perhaps are clear that we are the petitioners are were the defendants. We have appeared after receiving summons on a certain date. On the first date when we have appeared after receiving summons, we have sought for an adjournment for filing the WS. And thereafter, on the next date, we could not appear. Later on, we have shown cause that due to wrong entry in the advocate's diary, we could not appear. And on the first date of absence itself, it was proceeded ex parte and it was fixed for ex parte evidence. Now, Lordship, my humble submission here is that, all right, under Order 8, Rule 10, a range is allowed from passing a judgment to passing any other order. In case we fail to file a WS within stipulated time. Now, two things Lordship will consider here, that the order on the day of our absence, first of all, we have shown sufficient cause. Secondly, that day was on the 70th to 72nd day from the date of receipt of summons. That is, the outer limit of the CPC was also not passed, has not crossed. That is one aspect. And second is that under Order 10, Order 8, Rule 10, range is allowed that either pass a judgment on the basis of the plain or pass any other order. So far as I understand, Lordship, I have taken some help for my understanding from a 1999 case, that is Balraj Taneja and another, that in this case, what does this range mean? This range may mean giving an adjournment. This range may mean imposing some cost for filing WS. But here,
Mr. Counsel,
yes.
why you are making it very complicated? A simple issue. You filed a petition under Order 9, Rule 13, which couldn't have been filed. You should have filed an application under Order 9, Rule 7. That is
yes.
Second is, you failed to file your written statement on the day on which it is fixed. If you fail to file the written statement, then under what provision the court should proceed?
Lordship, I am only saying that the court can definitely proceed under Rule 10.
No. The court then proceeds under Order 9, Rule 6. You don't file your written statement, you don't appear on that date. Isn't it?
But Lordship, you have appeared. On the earlier date, you have appeared.
Earlier appeared,
Yes.
but that date you did not appear.
That date, yes. Yes.
So therefore, you come under Order 9, Rule 6.
Six.
So your
Six.
petition should have been under Order 9, Rule 7.
Rule 7. Yes, that.
Isn't it? Now the court has proceeded ex parte against you, stating that you have failed to file the written statement. Now you say that there is 90 days available.
Was available at that time.
Was available. Now the question is, normally it is 30 days.
Yes.
So thereafter, the court may, on exceptional circumstances, grant you an adjournment. It is not a matter of right to get it till 90 days.
That is
And
true,
if any
Lordship.
court has stated, I differ from that. 90 days is not a matter of right. 90
No,
days is a matter of discretion.
That's true.
But the outer limit of the discretion is up till 90
Up to
days.
9. Yes.
Then
So, Lordship,
what
here
case
what
do you
has
have?
happened, the court had already exercised its discretion once in the earlier date because we had sought an adjournment. So that was given. It is not a case that we are delaying the matter beyond a certain point. So what I am saying is that the discretion that is being used is on an
Why you are
extinguisher.
unnecessarily filing all these type of applications? Does your lawyer out there in the trial court doesn't know the difference between Order 9, Rule 7 and Order 9, Rule 13?
Now,
And it's not far off. It's just a stone throw distance from here.
at the Lordship, all right. So 13 and 7, I cannot deny that what is there is there. Should have been 7. But
When is the next date?
next day is on 24/4.
24/4. Okay.
Now,
We'll issue notice, only notice.
Lordship, one more thing actually.
Mr. Counsel,
Yes.
listen. I'm only issuing notice, making it returnable on 8/4. By that time, you get this thing served. will pass order on that day. Not on 8-4, 5-4. To notice making it returnable on 5/4/2024. The petitioner is directed to take steps upon the respondent number, the respondents by way of registered post PTD during the course of the day. The petitioner is further directed to take steps by way of trustee rooted to the registry of the court and file an affidavit of service on the next day. The court, taking into account the order dated 5/2/2024, which has been put to challenge, and also in view of the fact that the next date in the suit is 6/24/2022-24, is not inclined to grant it stay at the present for the present. So the interim order shall be considered on the next stage. The service will dispose it on that.
Okay.
Don't make things complicated. It's a simple thing.
Yeah.
And why are you filing it under 115% and 27%? Bagot daw. TRP. Yes, tell me. Yes, Mr. Kocha.
Right, Procedural.
What you are challenging?
In this case, my lord, the petitioner challenged the rejection of their objection under section 47 of the CPC, my lord. Here, my lord, the little facts are necessary because originally a suit was filed in the year 1999. My lord. In that suit, my lord, earlier, my lord, to that, the petitioner is petitioner number 2 and the petitioner in interest of the degree holders, my lord, they purchase 1 katha of land each, my lord. In my deed, my lord, there is a map, and according to map, my lord, I took over possession and constructed the building. Now, I do not know where they have taken possession, my lord, because on the same day, from the same vendor it was. Originally, land was more than 4 acres, my lord. Your lordship may be pleased to see this page 28, my lord. I have constructed my holding number 161 at Sundarbari Road. Then, my lord, it was in the year 84-85, my lord, that a construction, my lord. Then, your lordship may be pleased to see page 32, my lord. They have also constructed a building number 95, but road is totally different, my lord. Engineering College Road. This is Sundarbari Road, this is Engineering College Road. Then, my lord, what happened after the possessions were according to their team? According to the, my lord, their fail this, my lord. The petitioner constructed their building, my lord. Then, the petitioner in interest of the judgment, the present judgment, degree holder, my lord, they filed a suit. That suit was, my lord, your lordship may be pleased to see at page 33, my lord. That is title suit number 96/99, original. Then it was renumbered as 148/09. Then it was filed against the husband and the petitioner number 1, not against the purchaser, my lord. Your lordship may be pleased to see the schedule, my lord. A plot of land measuring at page 47, my lord. A plot of land measuring 1 kotha covered by tag number 77, old C26 new of KP pattern number 14, new 23 of village Mazdalpati. But here it is interesting, my lord, this schedule, in the schedule, my lord, they have given a boundary. But that boundary was not in the cell deed. His boundary, in that boundary, my lord, it was shown that on the west side, defendant number 1 and 2, that is the husband and the son of the petitioner number 2, who purchased the land. Then this suit was decreed. Your lordship may be.
Did you raise the issue? Did you raise the issue in the trial court as regards the boundary?
No, my lord. Here, without impleading the petitioner number 2, the decree holder demolished my house. The petitioner number 2. That is the main issue here.
Then
Now, their land, I do not know where their land exists, but this schedule was, they have imputed this schedule
so
here.
on the basis of the decree, they have taken possession.
No, that was the decree for declaration of right title and interest, my lord. Your lordship may be pleased to see. According, as per this decree, my lord, they filed a execution case, my lord. Your lordship may be pleased to see that is the.
It a declaration of right title, interest, and for permanent injunction.
Yes, that was there, my lord. Then it was against the, not against the, my lord, owner of the land. It was against some 2 other persons, that is the son and husband. Then, my lord, this decree, they filed an execution case, my lord. Your lordship may be pleased to see that was execution case number 1/13 at page 94, my lord. At page 94. An order was passed on 31/10/17. This is against for execution of that decree, my lord. They stated, today is posted for order of this instant misday case filed on the strength of the petition filed by the petitioner decree holder under order 21 rule 32 of the CPC on account of violation of the order of permanent injunction against the defendant judgment debtors by order passed in judgment and decree dated 9/9/11 and so in title suit number 148 of 609. Then what the learned executing court, your lordship may be pleased to see page 96, point for determination in execution case, my lord. Whether the judgment debtor and performer respondent number 1 entered into the decretal land by trespassing decretal land on 28/10/2012 and cut down the trees and unloaded construction materials and violated the permanent injunction in respect of the decretal land. Now, your lordship may be pleased to see page 98, last but second paramala. On analyzing the exhibit number 1, it appears that the sale deed executed between Ramena Khatun, that is the petitioner in interest of the decree holder, and Muhammad Kobiruddin Ahmed. Again, in exhibit 2, that is the copy of the Sitha showing the name of the Ramena Khatun, and exhibit 4 is the building permission, again showing the name of Ramena Khatun as landholder over the suit land. Further, exhibit 7 showing name of the performer defendant Abjan Nessa, that is the petitioner number 2 before your lordship, as Pattadar over dag number 77, 270 new, Patta number 14, 32 new. However, if we analyze all these documents, none of the documents speaks about the incident dated 20.
So the petition under order 21 rule 32 was dismissed. Then what happened?
Then, my lord, after the disposal of this case, my lord, as they may create some problem, my lord. So the petitioner number 2 applied for permission for renovation of her building. That was one. Then he again applied for partition of her land, but just one quarter of land, my lord. And the court, that is the circle officer, my lord, granted permission. Patta was separated, that number was separated. Thereafter, my lord, he applied for his permission, and against that, my lord, they filed an application before the PMDA that they have constructed boundary over this boundary, which was the boundary of the suit in the suit, my lord. Then it was nothing happened, my lord. Then they preferred a lead application before this honorable court. This honorable court, my lord, directed that the GMD should inquire the matter and dispose of the matter. Accordingly, notices were issued. Circle officer was deputed by the GMD. Then permission was found to be totally correct, my lord. Your lordship may be pleased to see that was the order.
Then
My lord,
now,
since you are
after the
possessing,
court directed the GMD to look into the matter.
your lordship may be pleased to see, this is interesting. Our partition of the land was in the year 2012. Then they filed another suit, my lord. That is title suit number 136/2013. That was filed in April 2013. The copy of the plaint I have annexed, my lord. Your lordship may be pleased to see. That is at page 71, my lord.
Then
Page 71. That is also against Faziruddin and Akhtar Hussain. That is the petitioner number 1 and his father. Then they have added suddenly, my lord. The
so they
petitioner
say
number
that they now come under section 6.
Section 6, my lord.
Then
Section 6, and in Section 6, my lord, court rightly decreed, my lord, is under Section 6, my lord, because earlier their possession was declared in that original suit, my lord.
but section 6, isn't it required that it has to be within 6 months he has to be delayed?
That is there, my lord.
But when was whether they were in possession at all earlier?
All these things were suppressed, my lord.
Huh.
Now, the suit was decreed, execution case was started, and in the wrong boundary, my lord, they executed the decree.
Now, this boundary of Schedule A,
That is the boundary of the original suit, my lord, 148 oblique. And that is,
page 76 is the original suit boundary.
yes, my lord.
Now, have they executed within this parameter?
That is, we do not know. That's why,
Yes.
my lord, I shall point out before your lordship one thing. Your lordship, they have filed objection, my lord, affidavit in opposition before your lordship in this case, my lord.
Lordship, we have filed it on Friday, Lordship. I think most probably that is not on record, Lordship. I have a copy. Can I give it to you?
We'll look into that. First, I'm yet to be satisfied for issuance of a notice in this case. Let me be first satisfied with that. Then I will trouble you. It's a matter of motion.
Now, your lordship, original decree was with regard to tag number 77, 326 new of KP Patta number 14.
Original decree was
Your lordship, their objection, I have also annexed, my lord. That is the copy of the plain. Original decree, my lord.
77 old 326 new.
That was the, my lord,
And
Katsapatta.
KP Patta number 14 and 23. Now this is in Jalukbari.
Yes.
So Jalukbari, there has been a new.
Jalukbari, my lord.
Huh?
Jalukbari. They stated it is
At
a-
that point of time, the settlement operation did not happen.
Thereafter, my lord, Dhamapati was issued. I have filed that before your lordship. Your
No,
lordship may be
here,
pleased to see
no,
my
no.
application, page number 50.
Mr. Kolita, kindly come to page 47.
Yes.
That is the original decree.
Yes.
Of 77 old 326 new of KP Patta
Yes.
number 14 old 23 new.
That is the land of Katsapatta, my lord. Your lordship, I have enclosed the Katsapatta at page 50.
No, that is the decree suit
No,
as regards
they-
the earlier decree.
They filed this suit over this, giving this schedule, madam. Giving this schedule.
Hmm.
Then I have filed that schedule land at page 50, my lord, Katsapatta. That is in SMS, my lord. I have given also the English copy. That is 14 for old, new 23, tag number 77, 326, my lord, 3.47 lakh. Here, my lord, the names of petitioner number 2, 1 Saraswati Bhuya, Farika Bibi, Saifuddin Ahmed, Anwar Hussain, Altaf Hussain were found. Then, my lord, what happened? Thereafter, my lord, I applied for partition of the land. And new patta number was issued. Your lordship may be pleased to see page 54. In Assamese, my lord, it is at page 55. Applicant present the case is taken for consideration. The Jarikarak submitted his report after duly service of the notice within the notice period. No objection was received from any quarter. Applicant Abjanesa filed the application for granting separate patta over 2.68 acre of land covered by Act number 270 of KP patta number 32.
Now let us see how does the trial court take into account. What is your objection?
My
Under section
objection, my lord,
47.
This petition, this decree was executed without impleting the petitioner number 2. No decree was against her. But the trial court, my lord, rejected the objection that during list, my lord,
But why did you file under 47?
that is in the execution, second execution, my lord.
Why did you file? If you claim to be the owner, then you have to file under order 21 rule 97. Why did you
No,
47?
at that time there was no execution, my lord.
No, this execution application, title execution case number 53 of 2018 was filed on the basis of the decree passed in the 2th of
Second-
2013. So if you have any independent title out there, then obviously you should have gone under order 21 rule 97. What is this going under 47? You are saying that the decree is not executable.
Yeah.
How can you say that under 47?
Because, my lord, this petitioner number 2 was impleted as pro forma defendant. No prayer was made against her. And section 6 does not apply against her. Because this section 6 suit was filed on the basis of the earlier suit. In earlier suit, she was not party.
But that decree has attained finality.
Now, my lord, after filing of this revision application before your lordship,
Where is it? This is this revision application is challenging which? The
your
decree
lordship
passed by
may
the
be
trial
pleased to
court.
see that read. They have filed the read, my lord. Your lordship may be pleased.
No, what are you challenging here?
Rejection of the application under section 47.
So you are not challenging the decree passed in section 6. Are you challenging that?
No, my lord.
Then,
Because he was not a
so
party.
section 6.
He was not a party and decree was under section 6 of the
Oh.
specific affair. There is no question of challenging that by the petitioner number 2. If they execute the decree against the land of the petitioner number 1, my lord, that would have been a different thing.
Why the petition number 1 and 2 are together? Why the both of them have filed together in this petition?
Actually,
So there must be something, a collusion or concert between them.
that actually I cannot say at this stage.
That is the most important thing.
But the petitioner number 2 is occupying her land.
So what? It seems both of you are interconnected. Otherwise, why will they make the performer defendant? And why the performer defendant didn't approach the trial court and say that we have nothing to do?
Your lordship may
That
be
land
pleased-
is not ours.
Your lordship may be pleased to see they have filed the writ, my
Now,
lord.
did the
and
performer defendant in that suit in 2013,
that itself is wrong, my lord. In the written statement, it was clearly stated that the petitioner number 2 was not implemented and she has no connection with the suit filed by the petitioner in interest of the decree holder.
so how has the this petitioner number, the performer defendant have dealt with that? How was his case dealt with? Did he say in his written statement that look here, my property is not this the property of which is mentioned in Schedule A? Did he mention that, or didn't he participate at all?
Yes, my lord. Your lordship may be pleased to see the written statement. And the learned court, my lord, that copy of
Where is the written
Page
statement?
78.
Huh?
that copy of the plaint of the second suit, my lord.
No, that I have seen it. Where's your written statement? The petitioner number 2's written statement. Is it at page 78?
He has not filed any my lord, separate written statement.
Huh?
He has
Any
filed
separate or they have joined together to file one written statement? Because if you see the order passed in Annexure 15, page 83, the performer defendant has been treated as a defendant.
nothing mentioned, madam.
It is there.
No.
They have not
statement
mentioned as
except-
performer defendant.
Except the word performer defendant, my lord. Your lordship may be pleased to see
So, did you receive notice of that?
85, my lord.
Now, did you
What the
receive any
learned court
notice?
wrongly held, my lord, that the defendants again admitted in their written statement that the pro forma defendant, who is the wife of defendant number 1, and who is later made as defendant number 3, had purchased. Where is that defendant number 3, madam? Written statement, your lordship may be pleased to say, where is the admission? They stated at page 14, my lord. I have annexed the written statement. In page 80, my lord, in para 15. With regard to the statements made in paragraph 9,
Kindly
Yes.
come to page 90 of the judgment. Paragraph 19.
Yes.
DW1 has also produced a copy of the NOC issued by the GMDA for construction of the building to the defendant number 3, which is marked as Exhibit E. Moreover, DW1 produced a copy of the holding assessment issued by the GMDA in respect to the RCC house in the name of the defendant number 3, which is marked as Exhibit so and so. Said document shows that the year of construction of the is in the name of the defendant number 3 as on so and so. Thus, from the above evidence and admission of the DW1, it is apparently clear that the defendants are in possession of the suit land as per present
my
by
lord.
constructing
That
the
document
RCC house.
I
Now,
have already
see-
annexed that document. Your lordship may be pleased to see.
It is true,
That
it is
document.
apparent from the above that the defendants are in possession of the sale. Plaintiffs have also successfully established that they were dispossessed from the Sulan animal. On the other hand, defendants could not establish that they were in possession of the suit land, and based on this evidence only, there is no hesitation in so and so. So, it has been categorically, the court has duly taken you to be also a trespasser. All right, you have to,
This section 6 suit, my lord, on the basis of the earlier decree. Earlier decree, she was not a party.
Mr. Kulita, you are to challenge this decree.
Yes.
You have not. If
That
you
was-
don't, if you
that was
don't,
not
these
necessary
attains as,
Because in the meantime, my lord, she has separated her parta.
so what?
And now,
Unless you challenge this decree, you cannot, because there is a categorical finding in paragraph number 19 and 20. Unless this portion is not set aside, the court, the executing court is bound to trace out that very land where the RCC construction is being made by the defendant number 3 or the petitioner number 2 is this land.
only one para of the written statement may kindly be seen, my lord, at page 80. Para 15.
Of?
Of my application, my lord. Para 15 of page 80. That with regard
Page
to the-
18
Page 80, ma'am.
or 80.
That with regard to the statements made in paragraph 9, the answering defendant state that the title suit number 148/09 was filed against the defendant number 1 and 2. But the suit land was sued in the name of pro forma defendant at the relevant time, who was not made party in the suit. Hence, the injunction granted by the trial court is not binding upon the pro forma defendant.
So that means we are not concerned with that execution in respect to that suit, because that application which was filed was rejected. Now we are concerned that you were in possession of that and there was performer defendant was not made
I
a
have-
party.
I have in possession, my lord, a different plot of land, totally. And they
If that is so out there, that is the,
No.
if it is a different,
Well, they filed the suit.
you have to therefore challenge it.
They filed the second suit, my lord, for recovery of possession measuring 1 kotha fully described at page 71, my lord. With described schedule subject matter of subject judgment dated 9/9/11 and decree passed in title suit number 148/09. They paid for injunction, my lord, under section recovery of possession under section 6 of their decretal land. Their decretal land against me, my lord, there is no decree. And my lord, interesting, my lord, now they execute the decree of the land. Notice was issued at page 64 of their objection, my lord, against one Akhtar Ali. And that too, the schedule of the land was completely changed, my lord. Execution of the decree. Here, my lord, I am reading. A plot of land measuring 1 katha covered by periodic pata number 14/32, tag number 77. As per previous old map, where it was mentioned in the decree? No, nowhere. Man. How the learned executing could go beyond the decree? This was executed against one Akhtar Ali. But his petitioner number 1 is Akhtar Hussain. And that, my lord, your lordship may be pleased to see, I have enclosed the order passed by the learned executing court rejecting my application under section 47. Only on the ground that your lordship at page 115. Periodicity record reveals that the tag number, pata number has changed during dependency of the lease. Where is the lease? The petitioner number 2 was not a party in the original suit. Our land is completely different with a different tag number, pata number. They execute by law the learned Munship directed to go back to the land. And I have shown before your lordship that their holding is existed in a different road. Now they showing my land in the west, my lord, they executed the decree.
Have they taken the area of the revenue? The revenue people?
Yes.
Nothing remains.
Earlier, my lord, in execution case, my lord,
The executing court knows all these things. There's no material mistakes out here. So there's no question of interference.
Lordship, they jointly challenged that order, Lordship, of decree passed in 136/13, Lordship, that before this court, Lordship, he has suppressed these things. He has not taken
Oh.
it. This was dismissed,
So
Lordship.
that is why you are not
This is
saying.
the order, Lordship. Lordship has dismissed it because it was abated, Lordship.
the executing court, my lord, earlier
And that was jointly,
Nazir refused.
all the three.
Nazir refused to execute the decree. Then the officials, government officials were examined by the executing court. Then he passed this order to go back to the land in the earlier state ballot of 1964 and execute the decree of over my land.
Mr. Koilta, I am not saying anything. I'm just thinking whether to issue
At
notice.
this stage, there's nothing to say, ballot, because they have executed half of the portion of my house was already demolished.
Now, have they taken the possession or
Yes.
not?
According to
Possession
them, they
done.
have said.
Execution case is also closed.
Then what is it mean? Nothing remains. Execution
No,
done.
no. Half portion of the land was
No, Lordship, it is already
they have
completely demolished, and Civil Nazir filed the report and executing.
Where is the civil service report?
Lordship, I have annex in my.
It is another question, my lord, your lordship may be pleased to see at page 53, my lord. Page 53, I have given the copy of the Jamabandi. After separation of my parta, there remains only 5.90 acres of land, not 1 kotha of land. They have demolished my total area, my plot, my house, my lord. Your lordship may be pleased to send the copy of the Jamabandi.
Page 181. It page 181.
Now, Mr. Kolita, what do you get in challenging this impugn order? 24/1/2024. What do you get?
My lord, the
If I
trial court
no,
totally-
let us assume
Yes.
this court interferes with this order. Then what happens?
The question of recovery and other things will come, my lord, because over my land, my lord, they cannot execute the decree. Let them execute. They got the decree, my lord.
They
will
not
execute.
only execute, they have executed satisfied decree. Proceedings closed.
That is wrongly after filing of this case, my lord. After filing of the seat application, revision application before your lord.
When did you file? Or you were only issued a notice? Or you are lucky to get a notice? Huh? Why the matter has come up for motion?
Two on the 23rd of February, my lord. Because as they have filed the caveat, my lord, we could not move before this honorable court, my lord, this application earlier. Because we could not serve the copy, they are all are busy over there. How can I serve? And without caveat, my lord, without serving a copy on them, my lord.
So this matter, let it come up. Notice has been issued. Okay, Mr.
M. Ahmed.
M. Ahmed, it appears from the record that on 28/2/2024, notice was issued. Mr. M. Ahmed, appearing on behalf of the respondent, submits that an affidavit in opposition has been filed. To list the matter again, on 26th of April 2024, by the the registry shall ensure that the affidavit is brought on record. We didn't see that a notice has been issued. And why this matter? The registry have listed it as motion.
My only prayer, my lord, they have executed half, my lord. Remaining portion, my lord, they cannot execute. That may continue.
No,
Let us
Lordship.
At least
It's
maybe
already
pass.
there. Lordship. Order is already passed. Execution case is closed. It is already, and even
Execution
have-
case is good. That is different.
we have acknowledged,
This,
Lordship.
this court have also taken note of that, the submission made by the learned counsel appearing on behalf of the respondent, that the execution in respect to the title execution case number 2, what is that?
Title execution case number 53/18.
53/18.
53/2018 have already been carried out, and the Nazir had also submitted a report on the basis of which the execution proceedings have been stopped, have been closed. Under such circumstances, there should not be any further. Nothing remains. What is there? They can't go ahead. Execution case is closed.
This matter, status quo should be passed, my lord.
Let us go for what?
A portion they have demolished, my house. Petitioner number 2's house. That is over a different plot of land with different holdings.
That is another aspect. We are not concerned with that. But what is the status quo now? They can't go ahead. How can they demolish once the execution proceeding is closed?
Now, my lord, it may be restricted. They cannot construct till the disposal of this
Why?
application. my lord.
No.
Because
That
they
is
have
not.
executed
That's.
the decree on
Is
the
that your
government, my lord.
prayer? Is that your prayer? No. So, hey, line to the next. Yes, what are you challenging?
Lordship, we are challenging an order passed by London member MSCT Sonitpur, my lord. Chief may kindly see page number 37.
Which order?
Yes, sir. Order dated 18/1/23, my lord. See, by this order, delay application was ongoing, my lord, without hearing the petition. Like there is no notice given to us. About the
Delay for what?
delay for filing claim application. Because there is a delay of 16 days in filing the claim application, my lord. Because the new MD Act, my lord, has brought a period of 6 months of filing
From?
the claim application from the date of occurrence.
When did the new MB Act come?
1/4/22.
1/4/2022.
The accident took place on 16/4/2022.
But whether rules being notified,
Yes, ma'am. The new motor MV rules also came into effect from 1/4/22. I have annexed the notification, my lord, at page 44.
which one?
Page 44.
Yeah.
In exercise of the powers conferred by the subsection 2 of section 1 of the Motor Vehicle Amendment Act 2019, the central government hereby appoints the first day of April 2020
MBL. Yes, which is the section?
purchase section 166 subsection 3.
But this 166 is not here. In this notification, in exercise of the powers under so and so, the central government hereby appoints the first day as the date on which the following provisions of the act shall come into force.
That, my lord, the amending act, ma'am. Amending act of 2019. ma'am. Lordship may kindly see section 166 subsection 3,
পুরোনো। নতুন কোন কোন?
new act.
Where is that act of 2019? No, where is 2019? Not this one.
Yes, sir.
Here, no. Number 2, inserted by Act 32 of
Yes.
Iman, Section 53,
Section
Roman
53 is
3,
there, ma'am.
with effect from 1/9/2019. How is this relevant? Here it says 1/9/2019.
So see, it was amended, my lord, but it was notified on 1/4/22. That it will come into effect from 1/4/22.
No, but why it is mentioned out here, it will with effect from 1/9/2019. Why it SO dated so and so. Earlier subsection 3 was omitted by act of so and so with effect from 14/11. Yeah.
SO is, my lord, 859E.
Show me that act 2019. Oh, here,
Here,
we
ma'am.
have
This
it.
is the act.
There was further amendment.
Yes, ma'am. 2019.
What does it say?
Section 160 subsection 3 was inserted by that amendment.
Huh?
Newly inserted provision.
No application
Earlier it
for
was not there, my lord.
compensation shall be
There was no
entertained
limitation
unless
for
it is
filing
made
claim
within
section.
6 months of the occurrence. But why is it made with effect from 1/9/2019? On the other hand, if in this book you see with effect from 1/9/2019, but this is from 1/4/2022.
22.
Oh, this was inserted
Yes, my lord.
but not given effect to.
Not given effect.
Issue notice making it returnable by 6th of May 2024. The petitioner is directed to take steps upon the response number 1, 2, and 3 by way of registered as well as usual within 3 days. The case of the petitioner herein is that section 166(3) of the Motor Vehicle Act 1988 which was inserted and given effect to with effect from 1/4/2022 stipulate that an application for compensation shall be entertained if it is filed within 6 months of the occurrence of the accident. The learned counsel, appearing on behalf of the petitioner, has drawn the attention to the impugn order dated 18/1/2023, whereby why this matter you have not challenged? We are in 2024.
Lordship, first of all, there was a miscase for funding delay. In that miscase, there was no notice issued to us. Only on the after the delay was condoned, the main case was taken up. Only in the main case we have received the notice.
But then you have appeared.
We had appeared. We had filed a
Then-
petition. We had filed a petition
Then
showing this that provision, my lord.
so
but
that
that-
point of limitation will be taken up by the learned trial court. Let it be.
Yes, Lordship. Lordship may kindly see page 43. Page 43. I'll read the order, my lord. Parties are represented in the petition filed by OP number 3, that is us. Right? Petition number so and so on 19/7/23 under subsection 1, rule 2 of 10 CPC by 3. There is an
So you are challenging both the orders, 18/1 and 17/10.
Lord.
Why you are not saying that? Challenge the by way of the instant petition, the petitioner. Have you challenged both or not?
Lordship, we have challenged 18/1/23 and the entertaining of the claim application by order date 27/12/22, my lord.
You have not done 18/1, the 17/10.
No, my lord.
Then-
Because my lord, that order, my lord.
If you are not doing it, then why should we entertain?
Lordship may kindly see.
No. Can I now, without setting aside this order of 17/10, proceed? Tell me. Because the trial court has already decided that point
Yes.
of limitation.
And they and the learned
Without
member
challenging
is
this
to-
order, how do I do it?
is to decide it again, man. By order at 17/10/20.
Understood. Earlier, without hearing you, that order was passed. Now, 17/10 order has been passed. So the court says that we have already decided on the point, and as such, we are not entertaining that. But you have not challenged this order. How do you take care of that? Tell me. If you don't challenge this order, would it be possible? Unless you have mentioned that you have challenged all the consequential orders.
Yes.
You have only challenged 18/1.
Yes.
Then the instant application has been filed challenging the order dated 18/1/2023 passed in Mise case number 02/2022, whereby the delay of 16 days in preparing the application under section 166 of the Motor Vehicles Act 1988 was condoned. It is the specific case of the petitioners herein that in view of section 166(3), which was inserted by section 53 Roman 3 of the Motor Vehicles Amendment Act 2019 and given effect to, with effect from 1/4/2022, the learned tribunal could not have condoned the delay of 16 days. The learned counsel submitted that this aspect of the matter was passed ex parte. This order was passed ex parte, and pursuant to the appearance of the learned counsel, pursuant to the appearance of the petitioner before the learned tribunal, this aspect was pointed out. However, the same was rejected by an order dated 17/10/2023. The learned counsel submitted that the very initiation of the proceedings by the order dated 18/1/2023 by condoning the delay was expressly in violation to the provisions of section 166(3) of the Motor Vehicles Act 1988, and as such, all further proceedings in respect to the said claims, in respect to the said proceedings, that is MSC case number 118/2022, has to be interfered with. Taking into account the said aspect of the matter, this court is of the opinion that the petitioner has been able to make out a prima facie case for which this court states the further proceedings of MSC case number 118/2022 bracket injury pending before the court of the learned member Motor Accidents Claims Tribunal at Tejpur till the next day. But you should have been more careful.
Lord. It is the law. My lord, it's a contempt.
I am appearing for 5, the next matter for respondent number 2.
Yes, Mr. Das, what are you challenging?
No, I am not challenging it.
No, the other matter.
Other matter, I am respondent.
TRPIO 92/94. Who has filed that? Yes, what are you challenging?
Order of amendment.
What amendment? Huh?
Lordship में peruse page 81 1. 81 was the execution case filed by the one of the decree holders.
Okay.
Page 81.
Hmm.
Rupchand Kucharia filed it, and his filed against the decree holder. In page 82, name of all the plaintiffs are listed. On the death of Mulchand Kucharia, the principal plaintiff, all the legal heirs are listed, and they were not made a party here.
Where?
Thereafter,
No.
in the execution case. That is permissible, I understand. And thereafter, page 86, you'll find the prayer of the execution. The decree was for realization of the area rent as well as eviction of the tenant. In the prayer, they have sought for realization of the area rent with costs and other things. And situated thus, we appeared before the learned executing court. We tendered this amount and also intimated the learned court that since there is a fresh agreement between me and one of the legal heirs of the earlier decree holder, so rightfully they have not included this prayer of eviction. After I filed that, they have filed a petition for amendment and including the prayer of eviction as well, which was allowed without hearing and without even serving a notice to the other legal heir of the.
Then?
That was allowed. That
Very
is
well.
what I'm telling.
Where is that order? This order, 22.
Order is at page 98, annexure 10.
This case has arisen out of Iman, prayed with Iman, praying for allowing the regard to make a minor connection in prayer.
The court at page 102.
So you are challenging this.
Yes.
Hello? We dismiss your petition with cost of 1 lakh.
Lordship. If I may submit your lordship, the date.
Nothing doing. This is a case of dismissal. This is a pure and simple case by which I still remember the judgment of Justice Krishna in the case of, I think, P. Arvindaram. That case, 1977 for SSC. This is a simple case of that. I give you 6 months to vacate. You could not have entered into any subletting or anything to that effect. Nothing has been done, or whatever may be, it is a separate cause of action. The execution will follow, and it has been rightly done.
Lordship, to my
We
understanding,
dispose of with a dismissal of 1 lakh.
Lordship, to my
Heard
understanding,
Mr. B.J. Mukherjee,
Lord-
another 50,000 upon you.
Lordship, if I may submit.
Nothing doing. Any more submission, go to Supreme Court. This is an application under Article 2 to 7 of the Constitution, challenging the order dated 19/2/2024, passed in Mize case number 28/2024, arising out of title execution case number 02/2024. The brief facts involved in the instant proceeding is that a suit was filed by one Mulchan Kucheria against the petitioners herein, who were the respondents, who were the defendants in the said suit. The said suit was registered and numbered as title suit number 2/2000. The said suit was filed on the ground of defaulter, on the ground that the petitioners herein, who were the defendants, were to be evicted from the suit premises on the ground that they were defaulters in payment of rent, as well as also on the ground of bona fide requirement of the plaintiffs. The said suit was decreed by an order dated 5/8/2010, whereby the learned trial court, that is the court of the Munsif Bongaigaon, in favor of the plaintiff, thereby holding that the petitioners herein, who were the defendants, were defaulters in payment of rent. However, the issue pertaining to bona fide requirement was decided against the plaintiffs in the said suit. Being aggrieved, an appeal was prepared by the petitioner's hearing before the court of the civil judge Bongaigaon, which was registered and numbered as title appeal number 35/2010. In the said appeal, the plaintiffs filed cross objection as regards the decision which went against them pertaining to bona fide requirement of the suit premises of the plaintiff. The first appellate court, that is the court of the civil judge Bongaigaon, by the judgment and decree dated 5/11/2013, disposed of the said appeal, affirming the judgment passed by the learned trial court, thereby directing eviction of the defendants, the petitioners herein. However, in doing so, the learned trial court, the first appellate court, decided the issue pertaining to default in making of payment by the plaintiffs, by the defendants against the plaintiffs, and decided the issue of bona fide requirement in favor of the plaintiffs. Being agreed, a revision application was filed before this court, which was registered and numbered as CRP number 19/2018. This court, by an order dated 5/6/2023, being aggrieved, a revision application was filed before this court, which was registered and numbered as CRP number 77/2014. This court, by an order dated 3/11/2016, taking into account that the judgment so rendered by the learned first appellate court was not in consonance with Order 41, Rule 31 of the court, reversed the said judgment and decree passed by the learned first appellate court dated 5/11/2013 and remanded the matter back to the first appellate court for recording a fresh decision on the issues by discussing the evidence available on record and keeping in mind the principles embodied in Order 41, Rule 31 of the court. Thereupon, the learned first appellate court decided the title appeal, being title appeal number 35/2010, by a judgment and decree dated 22/9/2017, thereby holding that the plaintiff, the issue of bona fide requirement as well as the issue of defaulter in payment of rent against the plaintiffs, and accordingly dismissed the suit. It is under such circumstances the plaintiffs filed a revision petition under section 115 of the code before this court, which was registered and numbered as CRP number 19/2018, challenging the judgment and decree dated 22/9/2017 passed in title appeal number 35/2010. This court, after hearing the learned counsels of our parties by the detailed judgment and order dated 5/6/2023, decided the said revision petition in favor of the plaintiffs. on both the issues, that is defaulter in payment of rent as well as also on bona fide requirement of the plaintiffs over the suit premises. This court, however, taking a considerate view of the matter, in view of the defendants carrying on a business, permitted the defendant a period of 6 months granted the defendants a period of 6 months to vacate the suit premises provided they submitted an undertaking before the trial court within 2023 to the effect that they shall vacate the suit premises within a period of 6 months from the date of the judgment, that is on or before 6/12/2023. It was made clear by this court by the judgment and order dated 16/5/2023 that failure to submit the undertaking within the said period, the plaintiff petitioners shall be, and the plaintiffs would be entitled to initiate execution proceedings for evicting the defendants. This court further made it clear in the said judgment that during this period of 6 months, the defendant shall not create any interest, shall not create any right or interest no. This court further made it clear in the said judgment and order that permitting the defendant to remain in possession for a period of 6 months shall not create any right or interest in favor of the defendants in respect to the scheduled premises. It was further mentioned that during this period, the defendant shall remain in possession of the suit premises as the custodian of the plaintiffs and shall not do any act or acts which may affect the rights of the plaintiffs over the suit premises in any manner whatsoever. You did not submit an undertaking.
No, Lordship.
Okay.
If I may submit this,
Eh?
Lordship may record this.
What?
Before the agreement, Your Lordship, there is a document of handing over possession to the sister. That is not annexed.
Who has handed over?
The tenant.
You have handed over
There is a document
to the sister.
to the sister. And then thereafter, the sister, I have entered into agreement with the sister.
Who has entered into agreement?
The same tenant. fresh agreement with the sister. The daughter
But
of-
was the sister a party to the instant proceeding?
yes, yes. That is, I was trying.
Huh?
In the CRP itself, your lordship, which I have annexed, the order, your lordship,
Indra Devi Surana.
Sister is the co-decree holder,
code if you
co-decree holder. Respondent number 2. Here.
page 51 is the order of the CRP, your lordship. And in that as well,
2 brothers, 2 sisters.
page 51 and
But why Ramkrishnan Maheshwari was not a party in the earlier proceedings?
he later on became a partner of that.
When?
In 1996, after
But this
That is-
proceeding was filed at that point of time. He was not a party.
he was not a partner. He
Why?
subsequently entered into an agreement, your lordship, a
When?
partnership. During the pendency of the, after all, don't have the exact date. Along with the legal heirs of the deceased, it was a sole proprietorship earlier, your lordship.
Anyway, my duty is to dismiss with cost of 1 lakh
Lordship may record.
and issue provided those persons in the contempt. I will issue notice against those. All this. This is a high time. You can't frustrate.
Lordship may record that.
Absolutely no. You have not enclosed it. I'll put a cost of 50,000 upon you on this.
I have enclosed the agreement, your
No,
lordship.
you have not brought this.
Not.
It further reveals from the records of the instant proceeding that an agreement was entered into, an unregistered agreement was entered into between one Indira Devi Surana and Sri Ramkrishnan Maheshwari. This agreement have been enclosed as Annexure 3 to the proceeding, instant proceeding, and is dated 13th of November 2023. From a perusal of the said agreement, it reveals that the said agreement purportedly have been executed by one Srimati Indra Devi Surana with one Sri Ramkrishnan Maheshwari. The said Ramkrishnan Maheshwari, under no circumstances, was not a party in the earlier proceedings. on the basis of the said rental agreement, purported rental agreement dated 13/11/2023, it has been mentioned that late Mulchan Kucharia was the landlord, who was the landlord, expired on 5/1/2023 at Delhi. It has been categorically also mentioned that in the said deed, purported deed of agreement, that there was no amicable partition of the said property at the time of death of late Mulchan Kuchari. It was claimed in the said application, in the said deed of purported deed of agreement, that that Srimati Indira Devi Kusturana was entitled to get the shop room along with 2 rooms residential accommodation on the back side of the shop room, being her share as per the promise made by her father. although there are two schedules mentioned in the said agreement, purported agreement, but an entire perusal of the said deed does not mention about any Schedule 1 or Schedule 2 in the body of the agreement. It is also very pertinent to mention that during the course of the hearing, Mr. B.J. Mukherjee, the learned counsel, have placed before this court a document of handing over, taking over possession of the shop premises by which the judgment debtor had handed over the possession of the shop premises to one Srimati Indira Devi Surana. But there is not a single whisper in the said deed of agreement, purported deed of agreement, about the same. It is also not understood on what basis that the handing over of the shop premises was only made in favor of Srimati Indira Devi Surana, if at all. Taking into account that in the meantime, the respondents, the judgment debtors did not hand over the possession. The decree holders filed a title suit, a title execution proceedings being title execution number 02/2004.
One second.
In the said execution proceeding, a copy of which is enclosed as Annex 6 to the instant application, reveals that the said application was filed by one Rupchand Kucheria. Wherein an amount of rupees 9,363 was sought for realization. No, wherein the execution proceeding, whereby the assistance of the court was sought for the purpose of realization of rupees 9,363.05 from the judgment debtors in terms with the decree. Pursuant to the filing of the said application, a warrant, a writ for delivery of possession, writ for possession was issued by the learned executing court. Immediately thereafter, a writ for possession was issued by the learned executing court, thereby fixing 19/2/2024 as for report. On the next day, that is on 19/2/2024, the judgment debtor number 1 filed an application under section 47 stating about the entry of the stating about the agreement dated 13/11/2023 entered into with one of the decree holders by one Sri Ramkrishnan Mantri, who is being claimed to be a constituted attorney as well as the partner of MS Bongaigaon Stores. It was also mentioned that the money of rupees 9,363.05 which have been deposited be handed over to the decree holder as full and final satisfaction of the decree. While the said proceedings was going on, an application was filed by the decree holder under Order 6, Rule 17 of the CPC, read with Section 151 of the CPC, seeking amendment of the prayer to that effect that there should be a further direction for recovery of the that there should be a further amendment of paragraph, the relief sought for in the said application for execution, to the effect that for recovery of khas possession of the decretal premises and hand over the vacant possession to the decree holder by evicting the judgment debtors and all other belongings from the decretal premises. The said was allowed by an order dated 19/2/2024, which have been impugned in the instant proceedings, on the ground that the same was allowed without giving an opportunity to the judgment debtors to file an objection. This court have duly heard Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner, and Mr. Sansiti, you are appearing? No, you are appearing for the respondent, number 1.
Number 1.
On behalf of the respondent number 1.
I am appearing for respondent number 2.
And Mr. B.C. Das appears for the respondent number 2. Mr. Das, did you file the execution proceedings?
No,
So you have no say as regards the amendment?
but we have a clash of interest with the respondent number 1.
Oh, well, maybe, but you can't say anything about that objection to the, you have no objection as regards the application file. If it is an amendment
Yes.
allowed, it will go. You want to file any objection, you can very well file an objection out there. You have nothing else to say.
No.
And Mr. Mukherjee, tell me, tomorrow, one execution application is filed. There is a prayer sought for. What is the big deal for filing this application under 227?
Lordship,
You have taken the basis that an application under 227 can be just thrown on the face of the spot. Then
Lordship,
what is this type of application you are filing?
order 21/15, when I have specifically pointed out that one of the four degree holders has created a fresh tenancy in my favor. And that
Then it is a case, has he decided the section 47 application? Has he decided? Then he has not decided that. He has only, no, that 47 is pending.
Lordship,
So that aspect will be decided by the trial court.
Lordship, that is not under challenge, Your Lordship, but there is an order in the main case as well. The miscase was, the order in the miscase is challenged here, Your Lordship, but in the main case,
Has he passed the order?
Yes, Your Lordship.
What?
Lordship, that 47 is not discussed anywhere, and straightaway police assistance is granted for showing that.
But you have not challenged that order.
That is not.
So we are not concerned with that order.
For that, I have prayed for transferring because of the. That is very-
Transferring also, I will ask the district judge to do so.
Because on the same date, Your Lordship,
You are not challenged that order.
that
We are
order-
not concerned. Here is a case where they have only allowed. This court have duly heard the learned counsel for the petitioner, Mr. B.J. Mukherjee and Mr. S. Sansati, the learned counsel appearing on behalf of the respondent number 1, and Mr. B.C. Das, the learned counsel appearing on behalf of the respondent number 2. So, this court is only dealing with the application. Is only dealing in the present application as to whether the learned executive court ought to have allowed the amendment to the reliefs which was being sought for to the amendment in the reliefs portion of the execution application. In exercise of this court, having perused the materials on record and also taking into account that the application for execution of a decree, and also taking into account that there is a decree passed by there's a decree passed by this court in its judgment and order dated 5/6/2023 in CRP number 19/2018 to the effect that the petitioner herein, that the decree holders would be entitled to not only the recovery of areas but also for recovery of possession, is of the opinion that the learned trial court, learned executing court was justified in passing the order dated 19/2024 for the purpose of granting, for the purpose of permitting the amendment so sought for in the application, amendment so sought for to the application seeking execution of the decree. This court therefore finds no good reasons for the purpose of exercising the powers under Article 227 of the Constitution, for which the instant writ petition, instant proceeding stands dismissed. Mr. S.C. Sansati, the learned counsel, for the respondent number 1, had further submitted that the Judgment debtors, in order to delay the further proceedings, have filed a transfer application before the court of the district judge Bongaigaon, being mistransfer case number 8/2024. This court is of the opinion that as a learned district judge, Bongaigaon is deciding the said application. Any order passed at this stage would not be proper. However, this court, taking into account that there is a judgment and decree passed by this court on 5/6/2023 in CRP number 119/2018, request the learned district judge Bongaigaon to decide the said transfer proceeding as expeditiously as possible. So with the above, the instant petition stands dismissed. Now, yes, contempt. Contempt is against whom?
It's the judgment debtor who have contested that.
What is the contempt?
Contempt is for a deliberate and willfully violation of the direction given by the Honorable Court in the judgment dated, my lord, 5/6/2020. They have not followed the direction, and there was a clear direction to get the suitable message within 6. At that 6 months expired, my lord, on 5/26/2000.
No, Mr. Sansiti. Mr. Sansiti, here a question of why should this court at all exercise the contempt power? You are already there in contempt execution.
No, my lord.
Therefore, this court did not ask them. This court only granted them 6 months provided they give an undertaking.
My lord, that is
They did not give an undertaking.
undertaken, my lord.
So under such circumstances, they did not.
Yes.
However, have you made out the case that this Ram Mantri or whatever fellow who he is appearing has nothing to do with these people? Have you made out the case in your contemplation to the effect that they, instead of handing over to so-and-so or whoever it is to the decree holder, they actually handed over to this Ram Mantri? You have not done that.
No, my lord.
Then-
I have made the statement in my contempt.
No, have you made that case?
My lord, my lord.
Only
say
this
that-
court have come said that this within these 6 months you don't create any interest.
My lord, that was not the direction. Direction was this, that within 6 months they shall not clear any act by which the right of the plaintiff has been affected. That was a clear direction, my lord. And that money, 6 months expired on 6/12/23. In the meantime,
Taking into
before-
account that the execution proceedings are pending, this court for the present is not inclined to issue notice in the instant contempt proceeding for which the contempt proceeding stands closed. However, the petitioner would be at liberty to file appropriate application if so necessary at a later stage.
my lord, only,
Huh?
because only my
You don't have a point.
regarding this contempt, my lord.
Absolutely no.
Clearly, my lord,
This court is not going to entertain.
will fully violate
Okay.
it, my lord. Will fully violate it, my lord.
Should I dismiss it,
I-
Mr. Should I dismiss it on merit? Then your whatever has happened in the earlier matter would go for a 6.
It's up to your lord.
Hello.
My
Okay.
submission, my lord, that
Well,
is
he-
give a wrong message, lord. Because
Wrong
they-
message, right message,
because
whatever message.
They are still in position, my lord.
Understood, they are in possession.
Position.
But you could not control one of your degree holders.
No, my lord. He never contested. He was brought on record because of one of the legal heirs of my father. There was 3 money degree holders: myself, my son, my brother, and my father. So he has been brought on the record. He resides at Delhi. There is no good relationship with us. So without our knowledge, without any information, when he has entered into agreement, we do not know much. When they have filed, the assistant did not come before the Supreme Court. They have filed claiming that they have created a tenancy, which they cannot do. And he has also made a wrong statement before the court that he is a judgment debtor. This Ramto. But he was not a judgment
He's not a
debtor.
judgment
He
debtor.
was not the
I
judgment.
say that.
So he was not the judgment.
Now you want, no, Mr. Hansiti, you want a dismissal properly or a dismissal with a liberty, which I gave you earlier.
With liberty.
I've given it.
With liberty, my lord.
Yes, what is this?
What if, I forget it at my senior counsel.
What order has been challenged?
Order dated 23, 11, 20,
23?
11, 2020.
What is that?
The order passed by the, it's page number 7. So the order passed by the learned court below. Rejecting the application by
What is wrong with the order? Have you paid the court fee?
Yes.
Arbitrator's fee?
yes, my lord, I have already paid.
What is wrong with the order?
Lordship, the payment was not made completely on the said date, and at the same time, the WS objection was about directed to be filed within 30 days. They have left the objection.
But So the respondent railways wants to get the award set aside.
Yes, madam.
So the date of service of the notice of filing of the award,
Yes,
that's the period of
that
limitation.
is the,
Then what is wrong?
but lordship, the award date was 31st of May of 2022. So according, the notice period starts from the date of award itself. But then again, a date was fixed on 21/9/2022 for filing objection as well as the award. But they has lapsed those years.
No, did they get the copy? That is the only issue.
Yes, the issue.
The date of service of the notice of filing of the award, did they appear on 21/9/2022?
They appear.
Huh? Respondents have filed their objection and contended that the respondents had no knowledge about the collection of the award on demand by the petitioner. The total fee to be paid by the union to the sole arbitrator is to demand, which was to be paid in 2 installments, and accordingly payment was initiated during May 2000 and the first installment was paid in March. Subsequently, in terms with this court's order dated so and so, the balance fee of rupees 300 dated so and so has been deposited in the court. So this court order in Mizze case number 37/2022 dated 21/9/2022 was received by the year on when? This notice was issued ex parte. This order was passed ex parte. Annexure B.
But lordship, there is a judgment of Guwahati High Court itself stating that that under this Act of 1940, Section 40, notice under Section 40 is mandatory and need not to be in written filing of award. Party present in court and having knowledge notice help.
Show me that. Now, was the respondent present in the court on 21/9? No.
The respondent was present,
Huh?
and the order was passed in the presence of the party. But the
No. Show me that the notice of filing of the award was received by the union prior to 1811. That's it. You have this judgment, an extra copy of this judgment. Read it, paragraph 6. In R.D. Gupta versus so and so.
where the award was filed in court on 26 of the filing of the award served on the Union of India. The petitioner said that the award was for June 26 and thereafter differences of the was in time having been filed within this, but it was updated in the case of the very day the award was filed with the court. The assistant to the deputy commissioner passed the following order with a record of
Kindly see order of 21/9/2022.
The petitioner in person and the counsel for respondent are present. This order pertain to petition number 2420 filed by Ganesham, petitioner in person.
And the last page 12. On depositing the amount of rupees so and so by the respondent in the court, copy of the award may be furnished to the respondent. At the same time, copy of the award to be furnished to the petitioner as well forthwith. So under such circumstances, without the copy of the award being furnished, being available, how can you file? Isn't it the requirement under section 14 to file it?
There was provided the other party.
If I could understand, madam, the case is like this. Some award must have been passed by somebody, an arbitrator. Now, what has happened? The petitioner or the claimant have duly paid his dues. The respondent was not paying the dues. And in view of that, the award was not given. Because what happens? The arbitrator keeps a lien on that award. He does not give the award. So under such circumstances, he moves an application before the court. To look here, I have deposited this amount. And the respondent is not doing so. So under such circumstances, I am not in a position to file the award. Therefore, the respondent was directed to pay the amount, which was done as per 21/9/2022. And on the basis thereof, they deposited the amount on 18/11.
Yes.
And the award was also given to them, and for which they filed on 22/11. So what is wrong?
Lordship,
Now tell me, can it be filed? Can an application be filed without the award?
but it was delayed from the date of the passing of the order. That is 21.
Understood. That's not the mandate of 113(19). 119 says, for setting aside an award or getting an award remitted for reconsideration, the date of the service of the notice of filing of the award. If you had no award at that point of time, where is the question of filing of the award? The award only came after an order of 21/9.
But Lordship, they had the knowledge of passing of the
Absolutely. But that's not the reason why.
but knowledge
Unlike
of,
if you see the Arbitration and Conciliation Act of 1996, it categorically mentions under 34(3) that if you want to file an application for setting aside, it will be from the date of service of notice of the award upon you. So the limitation starts from there. Unlike in this case, for setting aside will come from the date of filing of the award, when they file it. Because what happens, you see, there's a difference. By virtue of section 36 of the Act of 1996, it becomes a decree of the court. Whereas in the 1940, an award is just a piece of paper. It does not become a decree of the court unless that is filed in terms with for section 14. That is the difference. And as such, it becomes a decree when the court gives a stamp.
give it so that I can prepare my
Who is your senior?
Gita. Yes. Yes.
There's a stay.
So much.
No stay.
Okay.
Then what has happened? The proceeding is going on.
Proceeding is going on. That.
Then why should we unnecessarily? Yes, Mr. Dhiman.
Short statement.
Unnecessary. Why you are spoiling the court style?
Lordship, it is not unnecessary. The Supreme Court order is very clear from the date of knowledge of the party that award has been filed. But that is section 42 says. But in this case, something different. Because the arbitrator has not filed the award saying that he has not been given a remuneration.
Arbitrator doesn't file an award in terms with the 1940 Act. He does not. The arbitrator gives the award for which a party has to apply to the court, to making it a decree.
Lordship, we have applied to the court. Sorry,
When did you get the award?
That actually I have that date. I don't have a record because it was dealing with the main thing. Lordship, something. I am taking the date which is not like 42, but what the court says. It is something different. Is that the after payment, the court says file the award to the arbitrator. Arbitrator file the award.
Arbitrator does not file the award.
There was direction of the court.
No.
There was lordship that is on record. That is, it is okay. I agree, sir. It is not required to be filed. But I have made an application to the court that the arbitrator is not publishing the award kindly because
That they are not paying.
they are not paying. They are
So
not paying.
they were directed to
Not-
pay.
On my application, the court has directed the arbitrator to file an award.
Now, did you know what was the award at the time when you moved that application?
Award was with the arbitrator on.
So you didn't know. They also didn't know.
Look, I agree. That I
So how will they then file from that date?
Then I'm coming to the point. What happened? Ultimately, the London court has given the direction to pay so and so rupees to the file so and so rupees in the court and receive the award.
Okay.
That is 21.
I think this is a fit case for dismissal.
It is a vital. It is very good case from my point of view.
Okay.
Not
You-
lordship.
There's a case for going to Supreme Court.
Not lordship.
Heard your
Lordship,
name? Heard, Mr. So-and-so. This is an application challenging the order dated 23/11/2022, passed in Mizzi case number 61 of 2022. Whereby the learned district judge Punitpur at Tezpur held that the filing of the objection by the respondent herein was within the period of limitation in terms with section 119 of the Limitation Act 1963, in terms with article 119 of the Limitation Act 1963. The facts which can be discerned from the materials on record is that the petitioner herein filed an application under section 38 of the Arbitration Act 1940, stating inter alia, Act of 1940, before the court of the district judge Punitpur at Tezpur, stating inter alia that on account of the non-deposit of the arbitration fee by the respondents herein, the arbitration award was not published by the arbitrator, and as such sought for direction that the respondents herein be directed for payment of the arbitration fee and the consequent publishing of the arbitration award. On the basis of the said application, the learned court of the district judge Punitpur at Tezpur, by an order dated 21/9/2022, directed the respondent herein to deposit the said amount of rupees 47,212.33 in the court, and a copy of the award may be furnished to the respondent. It was also mentioned that a copy of the award be also furnished to the petitioner as well for forthwith. Pursuant thereto, on 18/11/2022, the respondent duly deposited the said amount of rupees 47,212 before the court by the check bearing number 130886 dated 21/11/2022. On the next date, an application, the objection was filed as regards setting aside the award or getting an award remitted for reconsideration by the respondents. This filing of the application, the filing of the objection by the respondent was objected to by the petitioner's hearing before the learned court of the district judge, Punitpur at Tejpur, on the ground that the said application was filed belatedly and not in consonance with Article 119 and was filed belated. The learned district judge, Punitpur at Tejpur, by the order dated, impugned order dated 23/11/2022, came to a finding that as the notice of filing of the award was served upon the petitioner, upon the respondent's hearing on 18/11/2022, and as such, filing the written objection on 22/11/2022 was within the period of limitation. This order has been put to challenge by way of the instant proceedings. This court, having taken note of the facts, above mentioned facts, and also the on also a perusal of section 14 and section 17 of the Arbitration and Act 1940, as well as Article 119 of the Schedule to the Limitation Act 1963, is of the opinion that the learned court of the district judge, Punitpur, have not erred in law or have committed any error in jurisdiction in passing the impugned order. Accordingly, this court finds no merit in the instant petition, for which the petition stands dismissed with cause. Yes, what is this?
Your Lordship, I am from Mr. H.R. Chokre. As the petitioner is not here.
What are you challenging?
I am on behalf of Mr. H.R. Chaudhary. My senior is not feeling well today. Kindly matter may be passed over for that.
Yes, Mr. Purkar.
My lord,
What is this
my lord, basically,
challenging?
my lord, in my understanding, my lord, suit is petition is not maintainable because
Because
the suit was dismissed by Lord Monship on the ground of limitation.
Hmm.
Therefore, it is an appealable order. Doctor will find the impugned order, Annexion 9 at page 84.
where a
All-
notice was issued, summons, nothing.
Nothing.
So it was a case of under,
It is a
should have
case
been dismissed
dismissed.
on the first day. It should have been, a plain should have been rejected.
That's right.
It is a, we will therefore construe it to be a rejection of the
Rejection.
claim.
So rejection of plain is a decree. That will become a
Understood. We can convert it subject to payment of the court.
only defects is that notice was not issued. No notice was issued to the defendant.
No, without
The
notice also the court can do.
Court can.
There's no worry.
Court can.
There's no quarrel with that.
Yeah.
But the plaint ought to have been rejected. Because if a plaint is rejected
Right.
as being barred by law, then obviously a res judicata would apply.
Yes.
But if
Obvious.
on other aspects it would not.
Therefore, basically, my lord, if your lordship comes to that conclusion, it's a decree, then it is an appealable decree is appealable.
Yes, where is your senior?
He is not feeling well today.
Who is your senior?
HR Chaudhary.
HR Chaudhary, where is he? There are many other people who are appearing. Mr. S. Talukdar, HR Chaudhary. And what is the interim order business? Suit being dismissed?
Interim order made until
What status quo?
No, my lord, there is no scope.
Yes, in the backdrop of the facts above, it is provided that both parties shall maintain status quo as on today.
That is, my lord.
Evacuated. Where is the question of status quo?
Doesn't matter.
In fact, madam, if this matter comes up again before this court on first, you will get a dismissal. You want the dismissal on the last day of the month or on the first day of the month? Which one? That is the only thing which one? Last day or the first day?
last day.
Today. Today is the last day. And the first day is first. Which one? It's a quick case for dismissal. Can't help you.
4 at 5. 4th of April.
No one on first, second. Fourth, this matter can't be fourth. Fourth is this matter, okay. I'll give you on third. Won't spoil your entire bihu.
Ma'am, I am not.
On third. Okay, list the matter on third. 3/4/2000 year for further constitution.
3rd of April.
3rd of April.
All right.
Finally, interim order made.
Absolutely no.
No, no.
This interim order is totally encourages. How can there be an interim order in there? Should have been dismissed. And you should have filed an appeal. Appeal not done. The trial court does not know what to do.
An interim order is not allowed to continue. Interim order is not.
No, there's no interim order. I'm not saying anything.
Yes.
Yes, what is this?
Please, your Lord.
What are you challenging?
Lordship, after cross-examination, I realized that there were some typographical mistakes
Where?
while recording. So I filed an application that the same may be corrected. And my petition was rejected, Your Lord.
25/2022.
Lordship.
What typography? What do you want?
Lordship, in the cross-examination, Lordship, may take up the cross-examination at page 46.
Where is your application?
My application is at page 53, Lord.
Today is the date fixed for the case. And so was cross-examined. What was the date fixed for? When did you file this application? On 2011/2020?
It was for DW. On the last date, that is on 8/10, I was cross-examined and discharged, and 21/11, that is the date of the filing of the petition.
Is the some error had reported while recording the cross-examination? I signed everything. Then why didn't you file an application for re-examination?
I have filed. In
Where
the
then?
said petition itself, in last line, I may be re-examined. I have written so, Lord. Only a single sentence was required to be corrected, because all throughout in my plain, I was seeking, I need the suit premises for my bona fide need. And in my evidence also, I have reiterated. Lordship, on the last date, my friend has considered also that this is otherwise known.
He would not. First of all, how petition is, you are asking us, making a application for judicial investigation, isn't it?
Not exactly, Lordship. I prayed that
Then it is a ministerial application.
Lordship, my
No,
applic-
Mr. Kandela, kindly tell me, is this an application seeking ministerial orders? You want judicial orders? Can a judicial order be passed on an verification? Is it possible? Tell me, I want to also get enlightened. This must have happened before 2002, I suppose. 2002.
no, Lordship, in 20
Then,
after the amendment.
then, how do you take care of Order 6, Rule 15.4, read with Rule 10 of the Civil Codes Rules and Orders? How do you take care of it? This type of petition. This is a simple question saying that, look here, I want to re-examine.
Lordship, we have pointed out on that day, learned court was also absent, Lordship, that was the last date before Puja vacation, on which date I
Why
was
did he
prosecuted.
sign out there? Didn't he read it?
He did it. It was an oversight. Lordship, kindly see
Where is the single word out there in your application that it was oversight?
Lordship,
Where is
that
the
not
single
there,
word
but
out there?
Lordship, may I just, Lordship, may kindly come to page 46 for a moment.
Why?
I just want, because the answer is, it is not a fact that I have any bona fide requirement for the suit property. If I ask a question to myself, whether the suggestion, it was the answer to the suggestion, whether they will suggest you are having a bona fide requirement for the suit property, whether that will be the suggestion. No, in my respectful submission, the answer will be no. So that was a mistake, Lord. In between, I do not was missing, only that. And all throughout in my plain, in my evidence, I reiterated that I need the suit premises bona fide. Only a
Typographical cannot
I
happen.
understand.
This typographical cannot happen
It
because
was mistake on my part.
this was taken by hand.
Yes, Dr.
Why are you saying about typographical? Why did he sign it? Where is that line?
Page 46, last line.
No, in the handwritten one.
Handwritten, yes, Lord. Page 52, Lord.
Hmm? Where?
Lord, page 52, last line.
It is not a fact that I have any bona fide requirement for the suit premise property. I do not have.
I do not have that.
Or it should have put as it is a fact. I think it's a case for re-examination. File an application, the court will consider.
Looks.
Unnecessary, why these matters should be. We don't set aside this order. The order is whatever may be. All your fault. Who is the lawyer out there? Trial court?
I was there.
Yes, you. We impose you a cost on the lawyer.
It was just an oversight. Two negatives.
No, it's all because of you.
It was in the open court, cross-examining was done, learned counsel was present on both sides.
But Mr. Counsel, let me tell you, when it is written out there, it is not a fact. It is on the basis of a suggestion. And when you ask him, do you have a bona fide requirement? He will say, no. Mean it is not a fact that I do not have. Okay. But if it is the other way around, the court is required to write that either not a fact is not required. I don't have a bona fide requirement. I have a bona fide requirement. Or it is a fact. This is how the court made a mistake. But then also, I am not going to correct whatever I did. I'm only giving him an opportunity to file an application seeking re-examination. That too on an affidavit.
Lord,
With the cost of 50,000 upon Mr.
Lordship, it is a small 200 square foot premises. Lordship, only. or it will-
200 square feet VHS if it is in Pennsylvania.
It
Where
is
is it?
inside the market.
Where?
GS Road, it is inside a market.
Yes.
And the rent is 2,000 rupees per month. It is in the report itself, 2,000 rupees per
Then
month.
give it to him for all life. Getting 2,000 is not helping. Anyway, this is an order passed. This is the instant application has been filed challenging the order dated 25/2022, passed in title suit number 214 of the 2018. A perusal of the state order reveals that an application was filed by the plaintiff informing the court that there was certain mistakes while recording the evidence, and as such, he sought for re-examination for the purpose of clarifying the said mistake. Full stop. Where is the order of re-examination? Maybe for re-examination, for clarifying the said mistake. Full stop. This court have duly also heard the learned counsel appearing on behalf of the party, on behalf of the petitioner who submitted that the mistakes which had occurred was on account of an oversight which the plaintiff did not see at the time of cross-examination, signing the deposition. However, at a later stage, when it was brought to the attention, when certified copy of the said,
The next day,
when did you take certified copy or not?
no, we go for the record and we found it on the next day.
However, on the next day, when this aspect was noticed, while perusing the records, the application was immediately filed for seeking re-examination of the plaintiff witness, number one. This court have duly perused the said application, and to the surprise of this court, the said application is not, though seeking a judicial investigation and also prayer for with a prayer for re-examination of the PW1, is not in consonance with Order 6 Rule 15 4 bracket 4 of the code, as well as the civil rules and orders as framed by the High Court. From the materials on record, this court is of the opinion that the petitioner, the plaintiff, is required to be given an additional opportunity so that an application can be filed properly, thereby drawing the attention of the learned trial court about the mistake, and also seeking the prayer for re-examination. Under such circumstances, this court interferes with the order dated, impugned order dated 25/2022, passed in title suit number 214/2018, and further grants the liberty to the petitioner. There's a stay? Yes. To file an application before the learned trial court on the next date so fixed by this court. Seeking re-examination of the plaintiff witness number one. This court observes that in the circumstance such an application is filed, the learned trial court shall duly consider the same, taking into account that the right of re-examination, that every witness has a right of re-examination. It is, however, made clear that this court have also taken note of that by an order dated 19/9/2022, the further proceedings of title suit number 214/2018 was stayed, and the said stay order was continuing. The state stay order stands vacated, and the parties are directed to appear before the learned trial court on 19/4/2024. On the said date, the petitioner, the petitioner oblique the plaintiff is given the liberty to file the application seeking re-examination as per the provisions of law on or before the next date, that is 19/4/2024. Failing to do so, this court observed that the order dated 25/25/2022 stands revived. Yes, what is this?
Yes, please,
One Sajan Bhajanka and this is Amit Bhajanka somewhere. Here you are coming this way.
Yes.
You are there. In between all these people are.
Yes, my lord.
Oh yes.
I am challenging the impugn order, my lord. I am challenging the impugn order at page 122, my lord.
Page
122, my lord. Before that, my lord, I want to write to a state and narrate in short manner the facts of that case.
No. What order you are challenging?
I am already challenging, my lord, at page number 122, page number 122, my lord.
122.
By which the amendment of the respondent number 1 was allowed. He filed an application for amendment of the counterclaim. That has been allowed. So before that, my lord, I would like to point out that I have filed a suit for cancellation of the partition deed, which has been executed without my knowledge among other legal areas. That suit was filed by me. And the suit premises which are under my possession is in pursuance of a tenancy agreement made by the defendant number 1, who was my grandmother. So when I have filed this suit for cancellation, they have filed a written statement, some counterclaim in the court. In the counterclaim, the counterclaimant number 2 stated that he is in possession of the suit claim. So he was not in the possession. I have also filed by tenancy agreement. Subsequently, my lord, this defendant by land already, he has a legal heir have not filed any eviction suit against. But he has filed another counterclaim that we have trespassed into this suit premises, and as such he wanted.
Mr. Sancity, what is the stage of the suit?
A stage of the suit, my lord, that is for evidence. That was fit for evidence.
The application when it was moved was for evidence at that point of time.
Now, subsequently, that was fit for filing the evidence. Subsequently, when this filed the application, the suit was not at the stage of evidence.
What was the stage?
Now that is
No, at that point of
at
time.
that time for framing this for furnishing the disproportionate.
So it has not gone into trial.
Still has not gone trial, but we have filed, we filed our evidence. But that was has not gone into trial. So, my lord, my submission before this honorable court that by the amendment application by which they wanted to insert a prayer portion for recovery of position that they wanted. So, on the basis of an FIR which was wrote in the year April 2010, no investigation was there, nothing was there. But on the basis of that, they have filed. I have also objected. But the learned court, while passing the judgment, that is very much interesting. My lord, may come at page number 123. The learned trial court, while passing the order, has discussed the case of another party, my lord. Your Lordship may come in the last paragraph at page 123. My Lord, I am reading, my Lord. In the backdrop of the petition number 2567, a written objection filed, the court has meticulously perused the real point of controversy between the party. It disclosed before the court that the trial of the suit not yet begun. This suit is filed by the plaintiff for declaration of the right title interest in the ground floor premises, so premises, a plate premises between so, and further played a degree of explicit from the contract dated so and so. The suit was not followed for a specific purpose of the
When did he file the counterclaim?
counterclaim, my Lord, they have,
Original counterclaim, when did he file?
they have filed in the year, my Lord, 2019, my Lord. That counterclaim was filed by them, my Lord.
When?
That was filed, my Lord. Your Lordship may kindly come to page number, my Lord. I am, my Lord, contact page number 42, amendment application 70 to 91, my Lord. Page
Hmm?
page number 91, my Lord.
Lordship, page
this-
61.
91 mane, this was the Madrid application for amendment of this counterclaim. That was filed by them in the month of
On
June.
9th of September 2016.
First, my Lord. That was first, that was filed by both the.
Then they say on 19/4/2019 they were evicted,
No,
and for which they want to bring this amendment.
Lordship, all throughout, from the plaint itself, I will show, Lordship may kindly come to the plaint itself.
No, not necessary. What is the stage of
In
the
the
suit?
plaint, stage
See.
for evidence, Lordship.
Now, I am not.
Yes.
Was there a stay?
No.
There was no stay.
They have filed an application that the original of partition deed may be called. We said that it is
No, anyways, the court did not stay.
not
So under such circumstances, on the basis of that, he has filed written statement.
Yes.
What remains? Hello. This is an application challenging the order dated 16/8/2022, passed in title suit number 146 of the 2016 by the Code of the Civil. What is this code? Civil Judge number 1, Kamrup Metro at Guwahati. Whereby the application sought for application filed by the defendant number 1.
Defendant number
Defendant number 2,
Who has filed it?
Defendant number 2,
Filed by the defendant number 2
Two.
to amend the counterclaim
Yes.
was allowed. Full stop. This court. Full stop. It appears from the record that immediately after the completion of the pleading in the suit, being title suit number 146 of 2016, it was alleged by the defendant number 2 that during the pendency of the suit, counterclaim, on 19/4/2019, the plaintiff along with the defendant number 3 had trespassed into the commercial shops and are trying to let out the shops to third parties. On the basis of that, an FI was filed on 21/4/2019. Taking into account that in the counterclaim, the relief sought for was for confirmation of possession. And now, in view of the subsequent events, there is a requirement for recovery of possession, the defendant number 2 sought for amendment of insertion of this fresh cause of action, subsequent cause of action, by inserting paragraph M and N after paragraph 22L of the written statement counterclaim, as well as also seeking the relief, insertion of relief F and G, F, G, and H to the counterclaim. objections were filed by the plaintiff. This court have duly taken note of the learned trial court by an order dated 16/8/2022. After hearing both the parties, observe that if the said amendment is not allowed, it would lead to multiplicity of creation of multiplicity of proceedings, and further, multiplicity of proceedings in respect to the same dispute between the parties pertaining to subsequent events. So it was under such circumstances the learned trial court had allowed the said amendment by the impugned order dated 16/8/2022. The said impugned order has been challenged. Impugned order dated The said impugned order has been challenged on the ground that the allowing such an amendment would change the nature and character of the counterclaim, and as such, the same ought not to have been allowed. I've heard the learned counsel for the parties and have given due anxious consideration to the submissions so made. This court, having taken note of the amendment, the application seeking amendment of the counterclaim, and the paragraphs which amendment along with, and also having taken note of the counterclaim, which was written statement counterclaim filed by the defendant number 2, is of the opinion that the amendments which have been sought for pertains to subsequent events, and the reliefs have also are also required to be amended in order to give full effect to the counterclaim so filed. Under such circumstances, the decision of the learned trial court by the order dated 16/8/2022 does not call for any interference in view of the grounds and reasons stated therein. This court, therefore, finding no error in exercise of the jurisdiction or any error on law committed by the learned trial court in the order dated 16/8/2022, dismisses the instant petition. Yes, ma'am.
Under respondent number 1, 2, and 3.
Hmm?
On behalf of respondent number 1, 2, and 3. Okay.
It's an application challenging the order dated 7/12/2022, passed in petition number 920/2011 in title suit number 67/2019, passed by the learned court of the civil judge number 4, Nagaon, whereby the application under order 1 rule 10, read with section 151 of the Code of Civil Procedure 1908, for short the code, was rejected. From a perusal of the said impugned order, perusal of the materials on record, it revealed that the instant suit was filed by the plaintiff seeking realization of an amount of rupees 16,84,711. From a perusal of the materials on record, it revealed that the plaintiff had instituted a suit being money suit number 67/2019 for realization of an amount of rupees 16,84,711 along with interest from the defendants. The defendant number 1 and 2, and the defendant number 2 and 3 filed an application under order 1 rule 10, read with section 151, for striking out the name of the defendant number 2 and 3 on the ground that they have resigned from the defendant number 1 company, and as such are no longer, and as such their names should be struck off from the records. Their names should be struck off from the suit. The learned trial court, by an order dated 7/12/2022, rejected the said application, and the petitioners being aggrieved, and the defendant numbers 2 and 3, who are the petitioners herein being aggrieved, have instituted the instant proceedings. Yes, Mr. Counsel. This is the subject matter of trial. Well,
But we are not the appropriate parties. I am only the project manager and the accountant.
whatever may be, you have to show it before the court by filing a written statement that they look here, this is what it is. You are, in fact, you are asking for a rejection of the claims insofar as the defendant number 2 and 3 is concerned, which is not permissible, because that it doesn't come within the ambit of order 7 rule 11. So this court, having taken into account this court have duly heard the learned counsels appearing on behalf of both the petitioner as well as the respondents. Further to that, this court have also perused the impugned order dated 7/12/2022, whereby the learned trial court had rejected the application filed by the defendant number 2 and 3 on the ground that whether the defendant numbers 2 and 3 have resigned from the defendant number 1 company, or whether the said defendants are not liable for payment of any amount, are mixed questions of law and fact, for which the same can only be decided in the trial. This court, having perused the grounds assigned in the impugned order dated 7/12/2022, is of the opinion that the learned trial court have not committed any jurisdictional error in passing the said order. Accordingly, this court finds no merit in the instant proceedings, for which the instant proceeding stands dismissed. This court, by an order dated 3/2/2023, had stayed the further proceedings of title money suit number 67/2019 pending before the court of the civil judge number 4, Nagaon. The said stay order stands vacated, and the parties herein are directed to appear before the trial court on 2nd of May 2025 for further proceedings of the suit.
Highly obligeous.
Yes, hearing completed.
Yes, your lordship.
Judgment reserved.
Yes, your lordship.
Where? Huh?
22 April.
Okay, then we close this. It has been brought to the attention of this court by the learned counsel appearing on behalf of the petitioner as well as the respondent that the learned district judge had reserved the judgment in misarbitration case number 34 of 2020 and have fixed 22/4/2024 as the date for delivering of the judgment. So taking into account the above, the instant proceedings have become infructuous, for which the instant proceedings stands closed.
Much obliged.
Out of the
Same.
yes, same.
Hey, it is,
District will be
12 and 13. 12 and 13.
13. District it is typed out as Golaghat, it is to be Gwalpara district.
This is Gwalpara.
Yes, both all it is earlier cases were also from Gwalpara district, but wrongly Golaghat.
Gwalpara could be. To order. You have an order. Same order, same date.
Reference case will be.
Reference case to you just give the details of the reference. It's Gwalpara.
Gwalpara matter. Date of judgment also same.
Gwalpara.
Yes, reference case first one 13 and my lord second one my lord 20.
13
And
the
second
one 20.
20.
I will be with the order. Huh? Oh, no. Admit for. You file a short application and yeah, you mentioned those matters. I'll correct it.
Yes, my lord.
You
I'll
mentioned it.
mention my
You give a mention memo to them. I'll correct it. There's a mistake committed by this. We'll make it to a Gwalpara Golaghat. Yes. Appeal against
Order judgment order 31/7/2023 passed by LA case number 20 of 14. Learned
appeal to admit করে দিব all for the record next it to the 14th April 13th May 13th May we'll call for the records you should know you are already appearing out there na to appeal admit কৰি দিব আগৰটো নিচিনা order খালি নম্বৰবোৰ চাই ল'ব ভুল নকৰিব দেই বহুত ভুল কৰিছে you cannot don't do something tell this বেলেগক ইমান ভুল কৰিছে বেলেগক এটা আছে let him be more yes what is this
Against the rejection of the injunction application by the trial court.
huh
Rejection of the injunction application by the appellate court.
which order
Order dated 29/9/2023.
appeal has been disposed of
No, my lord, pending for objection.
which order you are referring challenging
My lord, order dated 29/9/2023.
Page
171.
what has happened to the appeal
And they have appeared and they had it.
hey no can conclude AC to help it pull out Yes, what is the stage of the appeal?
The pending for objection having object.
Yes, Mr. Sharma, what do you have to say?
My lord, I express my submission before your lordship that the suit itself is not maintainable
Why?
because there is also another suit filed by the respondent number 2 against the respondent number 1 and the appellant. That suit has been pending in the court of the Munship number 2. So, in view of that suit which was filed earlier, then under section 10 of the CPC, the instant suit filed by the appellant before the civil judge number 2 is liable to be paid under section 10 of.
State is a different thing. Staying is different from granting of an injunction.
And secondly, my lord, on the due, the learned court below wanted to hear both the parties before passing the any order in the injunction matter. So thereby the learned court below has not committed any wrong.
But Mr. Sharma, as of now, there is some injunction order rightly or wrongly passed by this court. There's an injunction order passed.
No, my lord.
Yes,
Injunction order has not yet been passed. By
in this court,
of course, by the
there's an order passed of injunction. So we do one thing. There's a long order passed after taking into everything. We direct the first appellate court to dispose of the appeal as early as possible. Until then, this order passed by this court of granting an injunction shall continue till then.
in this respect, I have got to submit before your lordship that as a matter of fact, and his appeal before the learned appellate court has been filed under Order 43, Rule 1R. So, what type of order can be challenged? That an order under Rule 1, Rule 2, Rule 2A, Rule 4, and Rule 10 of the Order 39 only can be challenged. But their appeal as regards Rule 3, because the learned appellate court
Mr.
did not.
Sharma, this court does not ascribe to the view taken by another coordinate bench to the effect that in an order where notice has been issued, you cannot challenge the order 43 to 1R. The view, in my opinion, is contrary to the view taken by the division full bench in 1983. And as such, that view I am not ascribing to it. Whether the appeal is maintainable or not, let the trial court, first appellate court decide.
Yeah.
Only thing is that there is an order passed, detailed order passed by this court. That order of injunction shall remain in force till the disposal of the appeal by the trial by first appellate. And we request the first appellate court to dispose of the said appeal as early as possible without being influenced by the order passed on 19th. I think that is a fair solution to both.
Okay.
The instant appeal, instant revision petition under Article, this is an application under Article 227 of the Constitution, challenging the non-granting of a ad interim temporary injunction, ad interim ex parte temporary injunction by the court of the learned court of the additional district judge number 1 Kamrup Metro at Guwahati in Mizze case number 120 of the 2023 arising out of Miss Appeal number 25 of the 2023. From the record, it reveals that a suit was filed by the petitioners herein along with an injunction application restraining the defendant, his men, agents, workmen, and associates from raising further construction over the suit land in any manner, and also from changing the nature and character of the suit land in any manner, as well as restraining the opposite part defendant numbers 1 and 2, their men, agents, workmen, and associates from selling and alienating the suit land in any manner. The said along with the said suit, an injunction application was filed which was registered and numbered as Ms. J case number 919/2023. The Court of the Learned Civil Judge number 2, Kamrup Metro at Guwahati, by an order dated 14/9/2023, issued notice and did not grant an ad interim ex parte injunction. Being aggrieved, an appeal was prepared, being Miss Appeal number 25/2023 before the Court of the District Judge, Kamrup Metro at Guwahati, which was subsequently endorsed to the file of the Additional District Judge number 1, Kamrup Metro at Guwahati for disposal. In the said appeal, an injunction application was filed, being Ms. J case number 120/2023, whereby an injunction was sought for, similar to the injunction as sought for in Ms. J case number 919/2023. The Learned First Appellate Court, by an order dated 29/9/2023, admitted the appeal and called for the records. The Learned First Appellate Court further, in the said injunction application, being Ms. J case number 120/2023, only issued notice and did not grant the ad interim ex parte injunction as sought for. Being agreed, the instant proceedings have been filed by the petitioner before this court. This court, by the detailed order dated 19/10/2023, was pleased to grant an interim injunction till the next injunction restraining the opposite parties, the respondents herein, from proceeding with the further construction of the proposed boundary wall or otherwise changing the nature and character of the suit land, more specifically described in this application, as well as the schedule appended to the plain. The said order have been extended by this court from time to time. This court have duly inquired with the learned counsels appearing on behalf of both the parties as to what is the stage of the misappeal pending before the Learned First Appellate Court. It has been duly informed that the said misappeal is at the stage of objection hearing. Be that as it may, this court
My Lord, for filing objection.
filing objection and
Yes.
filing objection by the respondent. Taking into account that there is an appeal proceeding which is continuing, and there is also an injunction proceeding which is also pending before the First Appellate Court. In the opinion of this court, a further parallel proceedings being continued before this court would not be in the interest of justice. According, this court directs the parties to
Already next date has been given.
direct the respondent hearing from proceeding with the further construction of restraints the opposite party, the respondent hearing, from proceeding with the further construction of the proposed boundary wall or otherwise changing the nature and character of the suit land, more specifically described in the schedule appended to the plain, till the disposal of the appeal, being misappeal number 25.
Principle number 20.
Misappeal number 25/2023. It is made clear that the Learned First Appellate Court shall decide the said misappeal, said appeal, being misappeal number 25/2023 on its merits without being influenced by the present order as well as the order dated 19/10/2023 passed by this court. Further to that, taking into account that the said misappeal proceedings arises out of an ad interim arises out of an order not granting an ex parte order of injunction, the learned First Appellate Court is requested to dispose of the said misappeal proceedings within a period of 3 months from the date of the instant order being placed before the learned First Appellate Court. With the above, the instant appeal instant proceeding stands. None appears on behalf of the petitioner on call. It reveals from the records that on various occasions the petitioner has not been represented. Further to that, on 2/3/2022, when the matter was listed, a prayer was made on behalf of the petitioner that he would take steps upon the sole respondent within 7 days. However, from the office note dated 29/9/2023, it revealed that no steps have been taken. Taking into account the above, it seems that the petitioner herein is not interested to proceed with the instant proceeding, for which the interim order, for which the instant petition stands dismissed for non-prosecution. The interim order stands vacated, and the court of the principal judge family court, principal judge number 2, family court at Guwahati, Kamrup at Guwahati, is directed to proceed with FC civil case number 1238/2015 in accordance with law. The registry shall duly intimate the learned court below about the instant order.
I prefer an accommodation with my senior, my lord. His mother is not well, my lord. He is hospitalized, my lord. The matter may come on Monday, my lord.
What is this matter about? What are you telling me?
Lordship, I am the defendant. The suit. I am the defendant in the suit. They are the plaintiff. Evidence of the both sides has completed. Lordship. The stage of argument, they file a petition to adduce some additional evidence by way of adducing some certified copies. That has been already tagged. That record has been already tagged in the main suit. That is the case. That petition has been allowed against that.
Who is the plaintiff?
They are the plaintiff. The petition is page 45. Their petition.
At the stage of argument.
Yes, sir.
What do they want?
They want
to prove some certified copies of so which were very much related to so and necessary to prove. It is that the record of so has been called by the defendant by petition. The records of the year are now tagged with title number to so the deposition and to cross-examination related by activity in document.
Earlier occasion, Lordship, they have also filed similar petition. It was rejected. Against that, they have filed a revision. That was also rejected.
So they just want to mark those documents as exhibits.
Yes.
Nothing more.
But that record has been already tagged out.
So let it be marked. What is the problem? Unnecessary. Why should we? Yours, yes. You want an adjournment?
Lord,
Still you want an adjournment. When I am allowing dismissing his petition.
your lordship may pass out. Lordship may pass the order, my lord.
Okay. There may be an observation to dispose the source first within 2 or 3 months. So
Yes,
then
that I will do it. 2006 suit, na?
Yes.
He will only exhibit those
Yes.
documents,
Yes,
nothing more than
nothing
that.
more.
No, nothing. Only your evidence on affidavit shall be only limited to those documents.
So there was an observation of the learned trial court reduced additional evidence. There was an observation.
No, it will be only for the purpose of Mr. Borua.
My
It
lord,
will only be for the purpose of exhibiting, because if you see your basic petition only categorically says that these are the documents which are already there on record. However, we have failed to exhibit it.
but we have also paid for additional evidence, my lord.
Why? Then I'm going to, okay, we'll have it.
On Monday, my lord.
Why, man?
Lord,
Tomorrow.
tomorrow. My lord.
Tomorrow. This is for tomorrow. This
Okay.
is the matter tomorrow.
I'll oblige.
Okay.
If you can't go beyond that,
Lord,
what you have asked for is the court cannot give you more than that. If you that, then I'll dismiss the entire.
okay, tomorrow.
I'll set aside that order.
Tomorrow, my lord.
If you ask for more than that, your thing has to be only to the effect that this document is only exhibited, nothing further more. It's the matter.
I'll oblige.
Okay.
Yes, what are you challenging?
My lord, as per office note dated 31/2024, my lord, service could not be completed due to insufficient evidence.
Don't worry, we'll dismiss your petition, then service is not required. Okay.
My lord,
Now
we
tell
are
me,
challenging the order counterclaim, my lord.
what is the order passed?
The counterclaim was only on the, my lord, against the defendant, my lord. Defendant number 1 against the defendant number 2. Like, there's a Supreme Court judgment, my lord, which states that specifically, my lord, that counterclaim is not maintainable against the co-defendant.
Ah.
2006-12 SCC 78.
Then?
So our claim was that, my lord, partition in respect of only Schedule C property, Schedule A and Schedule B property was already given to the defendant number 4 to 6.
You are the plaintiff.
I was the plaintiff.
So what do you have the problem? Is it the co-defendant should have come before this court?
My lord,
Then it is not against you. You should have been happy.
it has been made in my suit, my lord.
So what? How are you
They also have
concerned?
a separate suit, my lord.
It is nothing. No relief has been sought against you. How are you concerned? You should be happy.
But it will again drag back the case because, my lord, evidence was already filed.
What?
Again, evidence was already filed by the PW1 and PW2. Again, it will drag back to the stage of the written state.
So they filed the counterclaim later on,
Later on, no,
after the issues being framed.
issues were already framed in
So
the
how they couldn't have done that in view of that judgment?
my lord,
Ashok Karla. Then why didn't you point it out before the court?
that was pointed out. My lord. Issues were framed, evidence was, my lord, also.
Then why that judgment was not pointed out? If that judgment is not been reflected, the court wouldn't have passed that order. What about the service?
Service, my lord, as per office note dated 31/2024, my lord, it states that there is insufficient evidence. I'll try to collect a proper. Whatever was given in the plaint, my lord.
Person can be located at the like.
In fact, they have knowledge about the passing of the stay order because I have already submitted the certified copy.
How many defendants, sir? Only one.
Defendants, you have 9 defendants.
No,
my lord.
respondent is only
Respondent
one.
only one. The,
So,
against the.
go and serve it at
Right.
home. You know the
Justice,
address.
I'll take the justice. Sir.
Okay. Mr. Iqbal, the learned counsel appearing on behalf of the petitioner, submits that the petitioner be permitted to take justice service upon the sole respondent. So, taking into account the above, this court fixes the matter again on 6th of May 2024. In the meantime, the petitioner is directed to effect justice service upon the sole respondent routed through the registry of this court and file an affidavit of service on or before the next day. List the matter again on list accordingly. Interim order passed earlier can continue till the next.
Deeply okay.
Wait, Mr. Lord.
Mm.
Lordship, as per office note, Lordship, as per process service report, Lordship, the notice was duly served upon the respondent through his sister-in-law on 19/5/2020, which is marked as flag Y in the second file, Lordship. And through
Unserved notice received back with the postal addressee not found. As per postal notice has been received by the sister-in-law of the respondent. Husband, wife,
yes, Lordship.
where do you stay?
Lordship?
Where do you stay? Nalbari?
Yes, Lordship. Mukalma, in the district of Nalbari. And 125 proceeding is pending before the learned the principal judge Nalbari. And this case is also, Lordship, learned court below is also fixed to fix the case. Today the case was fixed before the principal judge court.
You state.
Yes, Lordship. State till returnable date. That's why the case is also fixed there. On last occasion, when the case was listed due to paucity of time, the case.
The other side appeared today.
Their Lordship, I don't know. And they
It is at Guwahati.
Yes,
He
Lordship.
filed it at Guwahati.
Yes, sir.
You want it at Nalbari?
Yes.
Why? You have to come from Mukalma to Nalbari. It's more far.
No, Lordship. For the he has to be accommodated with her father. If
Understood. You have to come from Mukalma to Nalbari.
yes, Lordship, the communication is good, Lord.
Why?
Lordship,
Roads are good.
yes, Lord.
How far?
Almost 12 to 15 kilometers.
And to Guwahati?
Near about 60. Because through route.
When did you get married? 2021.
Yes, 2020.
And you have a child.
Yes, Lordship. Child born on 14/12. 14.
Have you filed written statement? Have you filed written statement? Soy passport. Itu Nalbari. You file your written statement on 6/5.
6/5.
Nalbari.
Yeah. Deeply obliged.
Service to complete HWD. None has appeared. Yes.
May I transfer it? Opposite party has filed an Okalat.
Yes, tell me.
Petitioner lives in Karimganj. Petitioner is the wife of the opposite party.
Both of you stay. Where did you file this application?
Actually, opposite party has filed this particular FC civil case in Guwahati Committee.
What do you, he permanently resides at Karimganj?
But he resides at Karimganj. He is showing that he resides at Dutiniali, Chanmari, Gitanagar. But it is not true.
Why?
It is not true because I have annexed one legal notice sent by the opposite party husband.
What is this?
Notice is on page number 13. And he has mentioned his permanent address is in Karimganj.
And where did you last reside?
Karimganj.
Huh?
Karimganj.
All of you?
Yes.
In 19 you transfer
Yes, yes.
Karimganj, and you file your written statement on 6/5. Transfer. Allowed.
Interim may be
Huh? Allowed, allowed. Go and file your written statement on 6/5. 6/5, don't file it, then ex parte. Yes.
I am for the respondent, my lord.
Hmm.
The suit is pending, my lord, before this.
Oh, did they withdraw?
My lord, the date is fixed on 8th of April.
Why? After the after my order being passed, then also.
My lord.
What is wrong with
Already,
the
my lord, it was
judge?
fixed on, my lord, 8/4.
Huh?
Already it was fixed on 8/4 before passing that order.
I have to prepone it. Hello. List the matter again on 10th of April 2024, on which date Mr. P. J. Saikia, the learned counsel appearing on behalf of the respondent, shall apprise this court as to whether the application seeking withdrawal of the divorce proceeding have been permitted by the learned court below.
Obliged.
Interim order passed earlier, nothing. Yes, Mr. Singh. What is this?
Was against the rejection of application filed under order 727.
Your application has been rejected? Your plaint has been rejected?
No, but I am the defendant. I filed an
What is your
application
ground?
for rejection of the claim. Which application has been rejected?
What is the ground?
Ground is, my lord, the suit is for a specific performance of contract. There are basically 4 landowners who are supposed to execute the agreement only one time, and that is the agreement that he wants to enforce. Other 3 never signed, nor they executed any power of attorney. So they are since not signatory to the agreement, my lord. This agreement at least cannot be enforced against 2, 3, and 4.
They are co-owners?
They are honored, but
Co-owners?
co-owners.
So?
But they are.
How much is the land?
The entire land. The entire land was supposed to be.
Then?
They never signed any agreement, nor they executed any power of attorney, and there was a contingency, my lord, in the contract itself, that the defendant number 1, the one of the landowner, he will obtain the power of attorney, which he failed to do. So since the contract was a contingent contract, and the contingency could not arise or never happen.
You are the defendant number 1. Or you could not do it.
I could not do it.
So you are asking that no clause of action. But what do you say about section 13 of the Specific Relief Act? That if some portion of the right falls upon you, then you are bound to that extent.
Ultimately, section 32 and 33 of the Contract Act has to be surpassed because
whether it is contingent or not is a question of fact.
No, it is quite clear, my lord, visible.
It's a question of fact. It doesn't show on the basis of the plaint. We have to see whether it discloses the cause of action.
On the basis of the plaint, my
He
lord,
may not be entitled for the entire land, but he may be entitled to part of it till of your right, only to the extent of your right.
Then what has happened, my lord, before the filing of the suit, the entire land was sold by all the 4 defendants co-owners together to defendant number 5, 6, 7, 8. Now the contingency that was anticipated in the contract itself cannot happen ever, because the right has been transferred. Now,
what do you say about section 19(2)(b)? It says it can be permitted. It can also apply to others.
First of all, let me take your lordship to the agreement. I think because ultimately once the agreement has been referred to, it becomes part of the plaint. So that can be looked into, my lord, whether that agreement can be enforced.
Whether it can, no. See,
my lord,
whether it can be enforced or not is not the question for this court to decide.
But this court
The
definitely
weaknesses
wants
of
to
the
see-
plaintiff's case is not a subject matter for which you can reject the plaintiff. No.
But there must be cause of action.
The cause of action is there. Because of the death, there is an agreement to that.
there are two.
Whether he wins or not, it's a different thing. He may be the worst of his case. He may not. But can this court withdraw it? More particularly, if you see, even if you see the basic idea of doing is that judgment of the Justice Krishna Iyer, the judgment of Krishna Iyer also says one thing. Then also you have to see whether the strictly the provisions of Order 7, Rule 11 will apply.
I had got one judgment, Church of Christ Charitable, which said that if there is no cause of action as against the other co-owners, against other defendants, the suit cannot survive. Let me place that judgment, my lord, then I will come to the agreement itself.
Yes, what did it say?
Kindly see the relevant portions, my lord. My lord, kindly see para 17. In the case in which the plaintiff to get a decree for specific performance has to prove that there is a subsisting agreement in his favor, and the second defendant has the necessary authority under the power of attorney. Order 7, Rule 14 mandates that the plaintiff has to produce the documents on which the cause of action is based. Therefore, he has to produce the power of attorney when the plaintiff is presented by him. And if he is not in a possession of the same, he has to state as to in whose possession it is. In the case on hand, only the agreement between the plaintiff and the second defendant has been filed along with the plaint under Order 7, Rule 14A, 14.1. As rightly pointed out by the learned senior counsel for the appellant, if he is not in possession of the power of attorney, it being a registered document, he should have filed a registration copy of the same. There is no such explanation even for not filing the registration copy of the power of attorney. I pause for a moment, my lord. In this case, there was existing a power of attorney which the plaintiff did not file. But in my case, there is no power of attorney, and that is the admitted position, my lord. So there is no question of its submission. Subsequent paragraph, my lord, in the light of the controversy, we have gone through all the averments in the plaint. In paragraph 4 of the plaint, it is alleged that the second defendant, as agreement holder of the first defendant, and also as the registered power of attorney holder of the first defendant, executed the agreement of sale. In spite of our best effort, we could not find any particulars showing as to the documents which are referred to as agreement holder. We are satisfied that neither the documents were filed along with the plaint, nor the terms thereof have been set out in the plaint. The above mentioned two documents were to be treated as a part of the plaint as being the part of the cause of action. It is settled law that where a document is stood upon and its terms are not set out in the plaint, but referred to in the position, in the referred to in the plaint, the said document gets incorporated by reference in the plaint. Para 19, my lord. Next, we have to consider the power of attorney. It is settled that the power of attorney has to be strictly construed. In order to agree to sale or effect a sale by a power of attorney, the power should also expressly authorize the power to execute the sale agreement deed, that is to present the document before the registrar, to admit execution of the document before the registrar. A perusal of the power of attorney in the present case shows that it only authorizes certain specified acts, but not any act authorizing entering into any agreement of sale or to execute sale deed. In my case, my lord, again, the power of attorney that you were supposed to obtain was never obtained. There are 23 miles. Under section 20,
the agreement was entered into with all the defendants.
No. The signatures were never obtained. Kindly come to page.
No, 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 no. It has been said that it is so and so. Kindly see page 26
Yes.
and page 29.
Yes, page
So and so self as well as the power of attorney holder of the first party number 2, 3, and 4.
Kindly come to page 27, my lord.
And 29. Forget about 27.
Okay. The original assembly button. Kindly come to the next page, my lord.
Yes.
The page 30, my lord.
Ah.
The first paragraph. कश्य पायना पत्र विधन कार्य जुगे प्रथम पक्ष टका आवश्यक हुआ तफसिल वर्णित माटी बिक्री करिब बिसरात और द्वितीय पक्ष खरीद करिब इच्छा प्रकाश करात आदि बराबर लगत तफसिलयुक्त वर्णित माटी.
This is for the power of attorney. No, he will obtain the power of he will obtain the power of attorney for the purpose of execution of the sale.
Kindly come to the next last 3 lines, my lord, of the first paragraph. प्रथम पक्ष बाकी प्रथम पक्ष पर अनुमति आमुक्तार नामा लय तफसिलयुक्त वर्णित माटी पंजीयन करिबले बाध्य থাকিব. Now, my lord, where is the power of attorney even to execute the agreement?
So,
no, my lord,
whether there was a power of attorney or not, he will ask him. The suit will be filed, has been filed on that basis.
But
you have
this
taken,
is admitted
you,
position, my
Mr.
lord.
Singh, you have taken the money. After taking the money, you are now trying to defraud these people. You are the defendant number 1.
Fine.
So, we dismiss it. There's a stay.
Yes, sir.
How long?
On a 2. But file
Cost of 25,000 into 2, 50,000 cost.
My lord, kindly give me time. My lord,
Absolutely
kindly, I am
no.
not asking for time for arguing. I am arguing right now. I am not asking for further time. Kindly see my.
I'm not going to say enough. That is enough. It
My
is a judgment.
The other 3 agreements by which the first agreement was renewed, my lord, this is the admitted position that there never was any power of attorney either to bind defendant number 2, 3, and 4, and the contingency that was enumerated, my lord, in the first agreement would never happen. And ultimately, they joined hands together and they sold the land to
So what?
5, 6, 7, 8. Now, my lord, the hurdle that is
And you see, there's a further degree compensation and damage minimum to the extent as an alternative relief. Then how can you say that?
So, my lord, the judgment of the Honorable Supreme Court.
Supreme Court judgment is for Supreme Court to listen. I am not going to listen to that. Anyway, this is an order, application under section 115 of.
Section 32 of Contract Act, my lord.
I'm not going to look into it. 32
Because
is for Supreme
the
Court.
contingency that was
No, there is no contingency. This contingency does not appear. Here is a contingency of subject to obtaining the power of attorney from so and so. In fact, no, that is also an agreement, part of the agreement that you are going to obtain the power of attorney. And if you cannot obtain the power of attorney also, the court will give you that direction. Whether it is permissible or not, that is another.
It's not permissible, my lord. Can anyone say that I am going to obtain power of attorney from so and so, and for that I am entering into an
So
agreement?
else you pay the 60 lakhs.
It is an agreement, my lord.
Else you pay the 60 lakhs.
It is an agreement not enforceable. It's not a contract.
This is an application under section 115 of the Code of Civil Procedure 1908, challenging the order dated 16/9/2023, passed in Ms. case number 64/2022, arising out of title suit number 223/2019. By the same impugned order, the learned trial court had rejected the application filed under Order 7 Rule 11 by the defendant number 1. From the materials on record, it appears that the defendant number 1, for himself as well as, where's the plaintiff? For himself along with
Page 40.
Annexure 1, my lord, page 40.
For himself and the defendant numbers 2, 3, and 4 had entered into an agreement for sale dated, what is the date?
Date is 17th April 2012.
17/4/2012 for sale of a plot of land measuring for sale of
1 bigha
the sale the land as described in Schedule A to the plaintiff. Full stop. It further appears from the plaint that out of the total consideration of rupees 7 lakhs, out of the total consideration,
that is not
Seven.
total consideration.
Seven
out of
That
the
is per
total
kata.
consideration, an amount of rupees 6,50,000 was duly received by the defendant number 1. Further to that, the defendant number 1 on his behalf, along with the other defendant numbers 2, 3, and 4, have extended the agreement for sale, extended the performance of the said agreement for sale by a deed of extension of the earlier agreement for sale dated 15/4/2015, thereby acknowledging that he had duly received the amount of rupees 6,50,000. Full stop. Subsequent thereto, by another agreement, the period of performance of the said agreement for sale was further extended by another 6 months. Full stop. Further to that, by another extension dated 11/4/2016, the defendant number 1, along with for himself and on behalf of the other defendant number 2, 3, and 4, duly acknowledged that the defendant numbers 2, 1, 2, 3, and 4 shall execute the registered deed of sale in favor of the plaintiff after obtaining the requisite permission for sale. Full stop. However, the defendants numbers 1, 2, 3, and 4 did not sell the said property described in Schedule A to the plaintiff, and instead, by the deed of sale bearing deed number 126 Roman 1 113 of the year 2019, executed the sale deed executed on 17/1/2019, transferred the said Schedule A land in favor of the defendant numbers 5 to 8. It is under such circumstances the suit was filed seeking specific performance of the agreements to sell as well as the subsequent extensions so granted, and also in the alternative seeking compensation and damages to the tune of rupees 60 lakhs 01750. And for refund of the advance amount with interest and compensation damage as may be calculated by the court, in addition to compensation under Section 73 of the Indian Contract Act 1872. Full stop. The said suit was registered as title suit number 73 of 2019 before the court of the civil judge at Tejpur. Pursuant thereto, the defendant number 1 filed an application under Order 7 Rule 11 for rejection of the plaint on the ground that there was no cause of, that the reading of the plaint did not disclose any cause of action, and the suit was barred by limitation. Full stop. The learned trial court, by an order dated 16/9/2023, rejected the said application filed for rejection of the plaint. On the ground that the perusal of the plaint did disclose a cause of action, and further, their suit was not barred by limitation. The learned trial court further observed that the plaintiff also sought for the alternative relief for refund of the advance amount. Full stop. It is against the order dated 16/9/2023, the petitioner, who are the petitioner herein, who is the defendant number 1 in the suit, had approached this court by filing the incident proceedings under Section 115 of the Code. Full stop. The law, I've heard the learned counsel appearing on behalf of the petitioner as well as the respondent. Full stop. The law as regards rejection of the plaint is quite is well settled. Full stop. In terms with Order 7 Rule 11A, the suit can be rejected if a reading of the plaint, it does not disclose a cause of action. Full stop. In terms with subclause D of Order 7 Rule 11, the suit can be rejected if a reading of the averments made in the plaint would show that the suit is barred by law. Full stop. This court, having perused the plaint, is of the opinion that the plaint duly discloses a cause of action, and as such, the question of the suit, the plaint being rejected under Order 7 Rule 11 of the Code does not arise. It has been submitted by Mr. S.K. Singh, the learned senior counsel appearing on behalf of the petitioner, that the plaintiff, under no circumstances, would be entitled to seek the specific performance of the agreement for sale, inasmuch as there was no power of attorney which was entered in, inasmuch as the defendant number 1 had executed the deeds, the various deeds, without a power of attorney being executed by the defendant number 2, 3, and 4. Full stop. He further submitted that the defendant number 2, 3, and 4 are also the co-owners of the said land, and as such, the question of granting a specific performance of the agreement does not arise. Full stop. This court, having perused the agreement for sale, which was a part of the documents filed in relied upon in terms with Order 7, Rule 14, and also having taken into account the contents of the plaint, it appears that the defendant number 1, the contents of the plaint specifically mentions that the defendant number 1 to 4 have offered to sell the Schedule A plot of land to the plaintiff and have entered into the various deeds of sale. Whether the said deeds were entered into by the defendant number 1 to 4, or whether the defendant number 1 entered into on behalf of the defendant number 2, 3, on behalf of himself as well as the defendant number 2, 3, and 4, or whether the defendant number 1 entered into without the authority being given by the defendant number 2, 3, and 4 are questions of facts which can only be decided in the trial of the suit. Further to that, this court also finds it relevant to take note of that the plaintiff have also sought for in the alternative for compensation on the ground that an agreement has been entered into, have also sought for compensation in the circumstance that the suit for specific performance could not be decreed in terms with the agreement. So, under such circumstances, it cannot be said that the suit does not disclose a cause of action. In this regard, this court further finds it relevant also to observe that merely that the suit is finds it relevant to observe that it is well settled that that suit that is well settled that it is well settled that merely because the suit may not be, the plaintiff may not be able to get a decree in the suit in his favor cannot be a ground for rejection of the plaint. Full stop. For that, bracket, Liverpool versus so-and-so reported in so-and-so, paragraph 151 and paragraph 152. Full stop. As regards the contention as to whether the suit was barred from a perusal of the plaint, where averments in the plaint barred by any law, as per the averments made in the plaint, this court have duly taken notice of the fact that that the said suit was filed on 10th of April 2019. And it is a specific averment made in the plaint, more particularly at paragraph number 30, that the plaintiff was in possession of a part of the suit land from 13/5/2016 to the first week of January 2019. Under such circumstances, the suit cannot be said to be, under such circumstances, it cannot be said that from a perusal of the statements made in the plaint, the suit is barred by limitation. Under such circumstances, this court finds no ground for interfering with the order passed by the learned trial court dated 16/9/2023 in Ms. case number 64/2022. And of course, in that view of the matter, the instant revision petition stands dismissed. The impugn order, the order dated 24/1/2024 passed by this court stands vacated, and the parties herein are directed to appear before the learned trial court on 2nd of May 2024. So taking into account that the instant proceedings have been unnecessarily filed, for which this court imposes a cost of rupees 50,000.
There are certain observations before which the observation in the trial court order that can be looked into so that it is avoided or responsible.
Absolutely no.
My lord, the
You have
observation-
taken the pain. You
No,
have
no, my
done
lord,
it.
kindly see the observation which are unnecessary and goes beyond the pleading of the parties. The observation, for a moment, my kindly come to page 56. Whether those are necessary, the observation of the learned trial court.
15,000 cost, which shall be deposited by the defendant number 1 before the trial court on the next date so fixed, 15,000. It is, however, before parting with the record, this court observes that the observations made by the trial court in the impugn order dated so and so, as well as by this court in the instant order, are only pertains to observations but relating to an adjudication under Order 7, Rule 11. As such, the said observation shall not influence the trial court in adjudication of the suit.
Public.
Yes.
Deputy the service is required for the private part. And tasking also the partner.
We vacate the order. You could not serve the trustee.
Other service already taken.
Huh?
Other service, they start as a usual process taken. Lot.
I am vacating the order. I have therefore fixed it 11/3. I have given it till 27/3. Why did I fix it? So that you can take service by way of trustee. These matters should not. So we vacate that order. This court had permitted the petitioner to take steps by way of trustee. However, the learned counsel appearing on behalf of the petitioner submitted that no such steps have been taken by way of trustee. Further to that, it reveals that steps have been taken by way of registered post along with usual on 21/3/2024. On 15
lordship, usual process.
on 14/3/2024. However, but the service have not been completed. Taking into account that the petitioner is not interested to take steps by way of trustee, this court is not inclined to extend the order of stay granted on 11/3/2024. List the matter again on 6th of May 2024. So the interim order passed on 11/3/2024 stands vacated. The trial court shall proceed with the proceedings of the suit, and you have not filed your written statement.
No,
And
I am not appeared here.
You have not.
May
The
please
trial court shall proceed with the proceedings of title suit D number 36/2023. The petitioner shall file their affidavit and their written statement without fail by 5th of April 2024.
But I have e-portal lordship. The case is for 25 not for hearing.
May please your lordship.
Vacated, shall file their written statement without fail on 2/5.
May please your lordship. As per honorable court order, steps are taken in timely. I have already filed flag A, my affidavit. Page 128 to 129.
You have served it?
Sir, already, sir. My request, your honorable court, I pray for extension of the stay order.
other side has not appeared. Taking into account that in pursuance to the order passed by this court, steps have been duly taken and the justice service have also been effected upon the respondent. This court fixes the matter again on 5th of April 2024. On the said date, if the respondents are not represented, this court shall proceed with the disposal of the instant proceeding. Interim order passed earlier shall then.